For
Number one, but I don't know what 1 to 3 of the number of
not today.
Number four. Item number five.
I don't. What is your?
But finally, madam, they have issued a notice, and in course of the day only you comply, it's an amend the officer. And this is the compliance report.
So it is infructuous.
Not he has to surrender, my lord.
You mean not infructuous? 41A, where is the scope of arrest?
My lord, I am relying on the Honorable Effects Court.
Yes,
I'll trouble your lordship with only one paragraph.
yes, which judgment?
This is, my lord, Asfaq Alam versus State of Calcutta.
What is the year? Which citation?
My lord, this is 23.
23.
Yes, sir.
This is considered in that case.
And my lord, kindly, and trouble your lordship.
Until, what is that case? Until. ANTIL.
My lord has a circular matter in the past.
Huh? Until, yes. This has been considered in until. Why are you, until now, after this case, until has been, has summarized everything.
But this is order passed by your lordship only in 24. Similar circumstances, my lord, 41 years combined, my lord.
May have been, will be guided by the apex court
And
judge.
this is after until man.
Yeah.
It has been referred in this judgment now.
We'll have to consider until now judgment.
But this is after until.
Maybe not considered. There are so many decisions after until.
My lord, may I read
We
out
will
the
have to
paragraph?
Off?
This judgment.
Why? You just gave it to me. The point is, there is a law declared by the apex court.
But this is Asfaq Alam.
Yes.
Yes, paragraph 12.
Whether it has, I am asking you whether this has been considered in Sutendra Kumar until or not.
My lord, kindly just
Whether it is considered or not.
Yes.
So show from Sutendra.
Yes. Considered my para 7.
In this
Page
case.
3, yes, sir. The judgment I have placed before also. Page 3, para 7.
Yes. Yes. In this case also 41A was issued.
Yes, madam. Para 12, my lord. And if I may read out, my lord. Or relevant portion is, my lord.
Where is the fact regarding issuance of notice
Yes,
under 41? Which paragraph?
That is, my lord. Para 12, madam. Page 8.
No, para 12 is page 8.
Yes, ma'am.
No, where does it say that notice was issued under 41A?
Madam, I'm reading out.
Yes.
In the present case, madam, this court is of the opinion that there are no startling features or elements that stand out or any exceptional fact, this entitling the appellant to the grant of anticipatory bail. What is important is not that the matrimonial relationship soured almost before the couple could ever settle down, whether allegations leveled against the appellant are true or partly true at this stage, which at best would be matter of conjecture, at least for this court. However, what is a matter of record is that the time when the anticipatory bail was pending can be divided in two parts. Firstly, when there was no protection afforded to him through any interim order between April 22 and 8/8/2022. Secondly, it was on 8/8/22 that High Court granted an order effectively directing the police not to arrest him during the pendency of his application under 438. Significantly, the investigation was completed, the charge sheet was filed, and in this case also the charge sheet had been filed after 8/8/22, and in fact, cognizance was taken on 1/1/2022 by the session judge. These factors were of importance, and though the High Court has noticed the factors but interpreted them in an entirely different light, what appears from the record is that the appellant cooperated with the investigation both before 8/8/22 when there was no protection granted to him, and after 8/8/22 when he enjoyed protection till the filing of the charge sheet and cognizance thereof.
The
on
court is asking you a
1/8/22.
simple question. Yes,
Kindly bear with me. Thus,
unnecessarily
once
you are
the charge sheet
placing
was
these
filed
facts.
and there was no impediment, at least on the part of the accused, the court having regard to the nature of the offences, the allegations and the maximum sentences of the offences they were likely to carry, ought to have granted the bail as a matter of course. However, the court did not do so, but mechanically rejected and virtually to rub salt in the wound, directed the appellant to surrender and seek regular bail before the trial court. Therefore, in the opinion of this court, the High Court fell into error in adopting such a casual approach. The impugned order of rejecting the bail and directing the appellant to surrender.
Unnecessarily you have read the entire paragraph. I was expecting you must have gone through it. You respond by saying yes, and that fact is absent from the paragraph that you are placing. Why do you do this? Who does it help by doing this?
My lord, kindly see. My lord, kindly
What
see.
kindly see? Thereafter, Anesh Kumar citation has
Yes,
been.
my lord.
So
What you are able to supply, by these matter, there is a strong.
that is not there in the order, sir. Why are you making a factually incorrect statement?
Kindly adjourn it for the day, madam. It will be taken up tomorrow. I'll send it to my lord.
Not today.
There should be report submitted will give you the.
Yes, the report be kept on records. Go through Satyendra Kumar Antil's case. His Lordship Justice Sanjay Kishan called judgment. Go through it. At the outset, I asked you, well, please see the judgment. Unnecessarily, you're relying on a judgment which is factually totally different from your case. Unnecessarily, yes.
Number 6.
Yes. As paid by the parties list on Friday. By the parties list on the date of Friday.
Item number 7.
What you are part of it. Your lordship. Yeah, in this case, the complaint lodged a complaint to the effect that in case of carbon which.
Where is the complaint? Where is the complaint?
Your lordship. Page 7.
Wait, there is a certified copy. How many petitioners?
Two petitioners, your lordship.
Yes,
Madam. I'm a statement.
yes,
Your lordship,
you have seen the FIR.
My lord, I've seen the affair. This is a case, my lord.
Yes. What is the
One
case?
Ramita Kedia. She is actually a citizen of Canada.
Maybe wherever she is a
Fine.
citizen,
Now,
that is
he
not
has-
relevant.
She has executed a power of attorney in favor of his father.
No, no, no. Come to
Yes.
the FIR. The complainant is one Naresh Agarwal.
That is the Naresh Agarwal, who is the purchaser of that property of
That's not the
Ramita.
issue. We are not concerned with the background. The FIR sets the criminal prosecution in
Now,
motion.
this.
He says that this is my land. I have the title deeds.
Mhm.
Some persons are coming and they're threatening dispossession or trying to forcibly capture
Right,
them.
right, madam.
This is
Now,
the nature
this
of
person
allegation.
has showed a power of attorney, fake power of attorney.
Whatever it is.
That is under challenge, my lord. Now they have shown,
Where is reference to the power of attorney? Show from the
my
FIR.
lord, after the investigation, my lord.
Where is it?
It's a voluminous CD, my lord.
What is this? They have any antecedents?
And see, not only that, in
And
another
against these
case,
two
my lord,
persons, there is nothing. They are saying that they are part of the conspiracy.
my lord, they have the power of attorney which was executed in favor of this lady, Shunita Shah.
Hmm?
Shunita Shah.
Yes.
Actually, that power of attorney was executed
Who
by
knows?
one fake person
Who
called as.
knows? Who knows whether it is fake, whether it is correct or not fake? That is.
And
hardly
actually,
any
this
allegation.
person, this original Ramita Kedia, he has not come to India in 2022.
That's
He has
not-
come until 2023. Now, what happened on the basis of that forged power of attorney? The entire land was sold to other various customers.
What is the allegation against these two petitioners? Just confined to that. What is the allegation? Show from the FIR. What is the allegation against?
Against him, allegation is that she was the attorney holder.
Where? Show it.
My lord,
Please show.
that is the affair, my lord.
Please show where they have said that she is the attorney holder. Please show.
Power of attorney. এই পাওয়ারটা দিয়েছে সুনীতা শাহ। সুনীতাকে যে পাওয়ার দিয়েছে। Alright, in this CD, we have found another power of attorney, but the power of attorney of which was registered in Kolkata.
Where is the allegation of a power of attorney being executed in her
That-
favor?
That came after investigation.
Or
It's
there is
not
nothing in the
FIR.
FIR?
FIR is not an encyclopedia of the
Oh,
entire
yes,
case.
yes, that is very well
And
established.
after investigation, because this purchaser, the
For
person who is
for
the
this offense, she is required to surrender. And why 41 notice has not been issued?
but they are absconding. They are absconding. It is issued by speed post, and they have not.
When?
They have not complied with.
Where is the notice
Alton.
issuance and where is the service? You find out whether it was.
Well,
part
it's
of-
there.
Issuance in the file and service are two different
Because
things.
they were absconding from their residence, then we have served through speed post.
persons, the bona fide purchasers, they came, they have stated there,
Where
there
is
are
the
161 statements of
service?
their.
Where is the service? This is only an issuance
Already posted, madam.
already posted, therefore I asked you. Issuance and service are two
Madam,
different
yes.
things.
Then I have to call the.
Find out if it was served and they have violated, they may
Madam.
not be entitled.
Madam.
If they're not served, then we'll see whether the notices issued under section 35 within bracket 3 DNS.
Okay, in item number 8, I beg to appear on behalf of the petitioners. Allegations are under section 126(2), 115(2), 117(4), 105, and section 3.
Sir, you have to give a translated copy of the FIR.
Then Lordship kindly keep this matter on Monday. I will give.
Keep it when?
Monday.
Monday,
Yes, sir.
for submitting as translated copy of the FIR. The Learned Council submits the matter may be adjourned to Monday. Stop list accordingly.
Grateful, Lordship.
Item number 9.
In this matter, Dr. Urdu will be appear in this matter, and come from CAP and certainly that is the same for third part.
Not today.
Item number 10, and for division of your laws.
You have given a copy?
Yes, stated.
Item number 6 and item number 10, like Lordship, I present Lordship is relating to this case, the same case area, and she has taken time, here, Lordship. So,
Yes, in 6,
number
he
6
has
and 10.
taken time till Friday.
Till Friday have taken time, good. Same case area, same case area. Same PS, Lordship.
They are different accused.
Yes.
Yes, different.
Grounds are different.
Better to be taken up together, so you can assist with the case then. List along with, give the number of it. Item 6,
Item 6 and 10.
Friday, date of Friday.
On Friday. Item number 6. And 10 because of that. On Friday, second.
Ah,
Will remain.
ah.
So that's.
Item number 11.
Yes.
So, Madam, we have already handed over the translated copy of the FIR.
Yes.
He has been intimated, this is the complaint report from the IO, and I've got the 164 statements of the victim.
Actually, my lord, they have lava affairs. Both are tender age. No such incident of penetrative assault took place at all.
You have given a translated copy of the FIR.
No, I have.
Yes, yes.
Translated Lordship, I'm handing over.
Aye, we have it.
The missing diary was not. Was that thing? Missing diary? It was it.
The victim is recovered.
Victim recovered.
Yes, fine.
Last PP said, her statement has already been recorded on the
164 statement has been recorded.
So there is no allegation of any.
Yes, yes, yes. There is no allegation because in the last paragraph she has categorically stated
Even
that-
in the FIR, there is
Yes,
no
yes,
allegation. It's only that she is missing.
Yes, he was missing. Fortunately.
Yes. As per allegations in the FIR, comma. Trans- Who are you?
I am the person who has made the application for cancellation of bail. Against my order, the order has become most stringent.
Let her, she wants to Monday. As fresh.
I am for the petition.
She's standing right next to you and she has just made the submission.
Yes.
So don't ask the court how she can see. Ask her how she can see.
Praveen Kumar, yes, I am for the state person.
Give a possible, short possible, my lord. It's-
But for the state, report has called for, report has.
This is me.
The court is not going to get into it. You decide amongst you.
My lord,
No question of short. I don't believe in short passover, either today or not today.
Look, I need to 5 days, so that I can serve them and serve a copy of.
All right. As prayed
Very good.
by the petitioner's counsel.
How?
She wants Monday. No, what service you will do? Monday.
The copy, the application that I filed, I want to serve of them.
Why do you want to serve?
What is the locus and I ask my question to they provide you statute in this case.
You instruct the state council.
He is not the defector lordship, he is the provide you statute for you.
60 pages taken for granted, Margaret.
Point is,
Violating the orders, Margaret.
point is your locus to address the court. The point is your locus. The point is whether you can point out. That is all. Whether you can. Let them do their work. If you want, you assist them. You can assist them. Yes.
As per direction
Yes,
of the court,
as per Monday.
what the
as-
court has stated.
As prayed by the learned counsel for the petitioner list on Monday.
I'm stated at the.
Yes, ask her to give an appearance. Where is she?
Lordship, I'm for the opposite party, Lordship. In this application, this is the relaxation the petitioners have filed, Lordship. But in this regard, we have filed one cancellation, Lordship, against the petitioners, Lordship.
Relaxation.
Kindly tag both the matters, Lordship, and heard both the same, Lordship.
This is for relaxation.
Lordship.
What is the, and you have filed for cancellation of the bill.
Lordship.
Then let it be heard together.
Lordship.
What is the number?
Number, Lordship, CRN AIM 51 of 2020.
Give a slip, give it on the slip.
Yes.
It is submitted by MS so and so that an application has been filed.
Number 14. Actually, but I am for the opposite person. I am for the state of Lordship.
The application is for cancellation of bail.
Yes, please.
Lordship, so the FR is written in Bengali, Lordship, but page 21 is the forwarding letter whereby we can find the fact of the case mentioned. Page 21, Lordship.
Memo of evidence is there.
No,
If the Lordship can.
just a minute, let us see the bail order first.
Lordship. Lordship, during the time of filing, Lordship, I have taken leave to.
Where is a copy of the bail orders?
Lordship, this is the bail order.
You are not annexed.
Lordship, I have taken leave to file subsequently.
What is the copy?
certified copy of the bail order is being handed over to the court.
Did the bill, anticipated bill application on 23rd of September, Lordship.
Therefore, regular bail is not to be granted.
Lordship, that may be granted, but
Then-
the seriousness of the offense.
That is no ground that anticipatory bail was rejected on 23/9. So what else? 23/9 anticipatory bail was rejected. What
Yes,
else?
Lordship, I have annexed the order sheet.
No, they are not disputing. You need
19,
not. You
page
need-
19.
You need not. That is not in dispute. What is the ground for cancellation?
Lordship, this
Yes.
is the one ground, Lordship, whereby despite the rejection of the
All right, what is the other ground?
Lordship, other ground is that after granting bail, Lordship, they are continuously threatening upon the.
No, there is nothing on record. Take it.
Lordship,
There is
I have annexed the one complaint, Lordship.
You may pursue the complaint. Where is the
Lordship,
complaint? Which page?
Lordship,
Lordship.
Monday.
Number one.
All the consecutive dates.
It's. So. Today is 1 year. The order sheet reveals that on the last 7 dates when the matter was taken up,
Grateful.
Item number two.
more.
Well,
Lines of the issue used in the case. The Commissioner has no interest in the property of the post. He is a stranger and he cannot remove the reference.
Lordship, I am for the respondent. Lordship, the petitioner was supposed to file an inquiry report by the solemn dated 9/4/2025.
None appears for the petitioner. For the appellant. List in the next week. I will buy.
Sir,
item number four. Let me take it. Yes, sir, first Sunday of the assistant headmaster.
Oh,
sir.
yes, stranger.
Not stranger, he's in a school.
Yes.
No time, I just tell you, I know, but one point I just missed yesterday, trying to, I know, you know the fate, even this.
Relying upon 2000 volume 7 SCC 553.
Yes. I refer to judgment. I think it's
2007 SCC 552, where the guardians had a
2009.
2000 volume 7 SCC. There is no such judgment.
Yes, I just.
2000 volume 7 SCC page 552.
That I've given a copy.
Yes, that you have.
That I said that the guardians having the.
Correct, the guardians have.
And second one is the excess commission. Now I just, I want to add one point. My God, I tried to argue one point. If the guardians having the right for the betterment of the school and the academic council, why the teacher, assistant headmaster does not have? The law says, Mr. Roy, the service matter, the appeal is, no,
No, if you are challenging the transfer of a stranger, you have no claim to the post in question.
I am no claim to the post. I am an assistant master. I challenge the transfer of the headmistress of the school on the ground that it
You
is
are the assistant
headmaster
and you are challenging the posting of
the assistant mistress of the school, of the same school,
mistress.
of the same school, on the ground that her transfer is in violation of the rules itself.
You are challenging the transfer of assistant
Of the headmistress of the
headmistress. You are assistant headmaster.
headmaster is a quiet school.
Yes.
I challenge, incidentally, I'm holding the post of assistant headmaster of the school. When I am officiating headmaster, the headmistress came our school, but it is in absolute violation of the statute rules. This is my point. Now, I rely upon the one judgment that CHN of our High Court showing that guardians having the right to challenge the recommendation of the headmaster or headmistress of the school if it is beyond the law.
You are not a guardian.
No, I'm not guardian. I say the principle, the paragraph 21, I said the principle cannot be why it should be applicable to me or not. The law says, and you see, Mr. Roy, paragraph 39 is the public intent. And another place you will also that excise commissioner judgment. But I just add 1 point, 2 points I'm trying to. If you can come my paper book, is that page 11.
Yes.
Page 11. Is a read finish. Is that judgment matter? Single bench judgment matter? That's also. Is a notes to argument.
Yes, Justice Prasad.
That I give you. But it's also can come page 11, paragraph 4. That it is submitted, your petition is not at all interested to oppose the action of the respondents for filling up the post of headmaster, administrator of the school portion. The demand of the petition is against the private respondent who managed to get the transfer order from the school service commission by ignoring all provision law. As such, you have to approach this Honorable High Court during attention to the illegality committed by the School Service Commission, transfer private resource from Bilpa access to which is not at all permissible in the eye of law. This is my abhorrent mind. Maybe you lost why I maybe you lost maybe these are management rules are there. I just
No, we are not interested in that.
no,
It may be contrary to the rules.
no.
Even if it is contrary to the rules, who are
You sir,
That is the issue.
that I'm trying to
That is the only thing.
I persuade you also by this.
Yes, we are not going to embark on that unless we are satisfied.
No,
that we have a
I'm
universe.
not sure. Of course, I have to cross the local standing bar.
Yes.
Now, what I'm telling you, how my rights may come.
Yes.
You also
No, but
this is
your specific averment is that you are not interested to oppose
but why I challenge I
because it is contrary to.
because now, my Lordship, that is what I'm trying to submit. I mean, I said, but I can't do, I can't deny. But these rules, under these rules, what I've said, I just try to, if you also kindly come, these are management rules. You also kindly come to,
No, then what for you are placing the rule? When you are not interested in this
no,
course, then
this,
why you are?
this rule says, what is the function of the assistant master? Trying to submit.
Yeah.
I just pressed two documents, when the, you also kindly said the rules, power of the head of institution.
Not required. You are challenging his transfer.
My Lord,
You are challenging his
I am
transfer
following his-
only.
I'm
What is the relief? Come to the prayer.
I'm challenging
Come to your prayer. Let's see
order
what
of
you are
transfer,
saying.
my Lord.
Come
No,
to-
I can't, I'm saying, my Lord, the order of transfer. But this order of transfer. B and C, yes, B.
Nothing else. That is only.
But what I'm trying to say, was as a assistant master, I do not have the locus money. But can you see what
Sorry.
what I'm trying to submit, can you see the rules for a moment?
Yes.
Then can you come to rule 22B? 22B.
See, whatever you want to submit has to be in furtherance of the prayer made in the writ petition.
Yes.
What is your prayer in the writ petition?
It is a
One
cancellation.
writ petition cannot be filed to say everything.
No.
Your submission has to be confined to the relief you have claimed.
Yes.
You have claimed no relief for yourself.
I'm not. I can't do it because because my and you also is trying to. I'm going to try to submit, my Lord, my locus.
This one. This will not work. This will also work. It was working in the chamber, it is the same. No, this was work from the chamber. So then you working here also. There it was connected. And here, oh, it is connected. All right. Yes.
My Lord, I just your Lordship is absolutely correct. I holding the post of assistant master. I have challenged the order of transfer of the headmistress of the same school.
Only, that's all.
Now,
Nothing else.
Now, as being assistant master, I have some other roles.
But
which
that's not the issue here. You cannot make this a forum to say everything regarding your service. You have to confine your submissions to the relief.
I just.
Your only relief is that his transfer is bad.
But
That's
nothing-
all. You could have made a relief that because of his transfer, he's interfering with my officiation. I am entitled to continue. That's not your
No,
prayer.
this is
That's
not
not your issue. So
but
therefore,
my
there's no
role-
issue of going.
but
Therefore, your role is immaterial.
I'm showing them that there's some role.
Not material.
From their own documents. I just-
Maybe you may be having a role.
Like-
Without seeing, we accept that you have some role. You have no relief. Therefore, that's
Role
immaterial.
is that with regard to the school administration.
Maybe, but there is no prayer of any kind. Only that the transfer is
But
illegal.
this is a main
That's
prayer, but you're saying
No,
how.
where is the other prayer? So,
I do not have, because
Then
well,
finished.
how I challenge it, I just saw two
sorry,
documents.
we are
Then
not
you-
doing
You lost kind
nothing beyond the prayer. This is not an open forum to say everything.
No, this is not for, these are rules, my lord.
We
Rules
don't
are-
want to go into the rules,
Rules gives the power me.
but you are not claiming any power. Unless you are claiming a relief, where is the question of going?
Given to act as a official head. You also.
There is no prayer in this regard.
You're trying to say what?
Come to the prayer, page 24.
No, my prayer is I challenge the suspension.
That's all. That's all.
My lord,
Sorry.
you also said, as assistant master, you do not the
We will
right.
not allow you. We will record that we have stopped you from making submission in this regard because there is no prayer. We will record that. This is not we can't just allow you to say anything and everything
This is the
that comes to your mind.
I've been engaged, my lord, just one minute.
Sorry, this is not the way.
104, for a moment, 104.
No, sir.
Can you see that before this I wrote this letter, can you see page 104?
You may have, there is no relief claim.
Can you see 104, for a moment, man, can you see, because I wrote the letter to the principal secretary.
Yes,
Can you see page 104 for a moment?
yes. Read it for yourself. You read it. What is the legal position when a writ petition is filed like this, invoking the extraordinary jurisdiction for extraneous consideration, then what the court should do? What is the law?
I'll confess it.
Then what is the law, sir? 2013 for SCC, take it out, 465.
Yes.
Then
This
that should invite some consequence also. This can't be allowed. This is not a forum for this. This is a forum for agitating rights
Your Lordship.
and grievances.
Your Lordship, I
This is not the forum for this.
that he should not do it. Because-
No, we don't know whether he should or we should not.
I just want
What
to
is
see.
he trying to
But-
achieve?
But I just trying to.
What is the law is very
Law
clear
is
in
very,
this.
law is very clear, my lord.
Yes, that if
Unless
someone,
there's a legal,
if someone invokes
Grievance-
the root jurisdiction in such a manner
but
for
extent-
some extraneous consideration,
but
then what
extent-
the
but
court should
extent
do,
Commissioner says otherwise, my lord.
that you have already argued. Don't worry, we will consider both the judgments.
One,
But
I
we
just-
will
I just
consider
want to
this
the-
also now.
I just want to facts.
So therefore, we are showing you that now we will consider this also.
213.
Yes,
But
you
that
say
I-
whatever you want, we will
No.
consider everything.
You just can come to.
Yes.
Tell 104 for a moment.
This may entail consequences, we are just making it clear. Yes, 104.
Can you come to 104 for a moment?
Yes.
This is the appointment letter. Can you say last line, last line?
Yes.
President, is got it at last two lines.
Yes.
President, Secretary of Main Committee, Guru Sri Guru Vidya Mandir with direction to verify the release order and other document before joining. So my lord, I am the Secretary of the Main Committee at that point of time because I'm obviously a headmaster. So we have been asked to verify all the orders, being a secretary. Now you can come to immediately wrote to the page 44A. Page 44A, we wrote the letter to the president of the board, my lord, that this order transfer is bad because of, I've given a, that has not been considered. Can you see my page 44A?
Yes. So
My
you have
lordship-
written, we are seeing it.
You see, then my
No,
lord.
no, we are seeing it, 44A.
I'm lordship, this is my duty, I'm trying to, I know.
Please,
My lord,
please,
I
44A.
think I know the judgment, the
Yes.
judgment.
Yes,
My lord, when, I see, when the appointment was given,
yes.
the board says you must verify all documents.
What is the date of his transfer?
Sorry. This is 30th November 2021.
So before his transfer, you have given a letter.
No. After this,
What is the date of the letter 44A?
sorry, but no. Sorry. Sorry, my lord.
Therefore, we are saying this, we can't just look into everything that you show us. You're relying upon some objection even prior to the transfer order.
No. There is two points of transfer order. And they are saying, just now I. Sorry, my lord, sorry, page 48, but
40?
A, small a. Sorry, my lord, sorry, my lord. This is earlier though that was revoked, then
Again, you are showing letter of 8/11/21.
yes. The transfer, after transfer,
You said transfer is 30th November 21.
no, recommendation is before that. Sure. I say date mine. And then I also can come first, page 36. First recommendation, then I made the, and it's page 36. The date is 29th October 2021.
Again before the transfer.
No one.
What no, my lord? You have said transfer is 30th November.
Yeah. No. It says, this is, I did not read. Sorry, right? That's absolutely correct. But it is very 8 November, right? Then I'm sorry. I'm sorry. I,
Heard the parties. CAV will pass the order the next week.
sorry, my.
No, it's all right. We had asked, adjourned it to enable you to make some argument today,
Yes, but
but apparently we don't know. Anyway, let's call
I
the.
tried my best, but facts.
Yes,
13 one I read, but this 14 is against me.
yes, next case. No need to be sorry. Yes. All.
Lord, in item number 5,
Lord, I appear in support of this appeal.
Lord, I beg to appear on behalf of the state.
Yes.
Lordship, I appear on behalf of the Central Pollution Control Board, respondent 5, Lordship.
Yes.
Lord, the appeal is directed against an order, Lord, by which a contempt application has been disposed of. Lord, the
Lord,
situation
he
is,
had a
Lord,
preliminary objection.
Yes,
I will,
yes, he must have been informed about your objection. He must be.
Right.
so Lord, I will address the Advocate General's preliminary objection, Lord, before I proceed with the appeal. So allow me to, Lord, indicate what was the scope of the contempt application. Thereafter, Lord, it will be relevant for me to address the objection, the preliminary objection. Lord, the
Mr.
writ
Bose,
proceeding was,
is there any way you can increase the volume of your audio feed from that side also?
Lord, is it better now?
Somewhat, yes.
Lord, a writ proceeding was initiated. Lord, challenging an action of the state, Lord, in discriminating one of the agencies in respect of biomedical waste disposal units. Well, there is a contract which has been issued based on a tender process, and the contract, well, there is a clause contained in the contract which specifically contemplates that if there is any subsequent tender, the discovery of the price of the subsequent tender would be available to me. So, well,
Would
our
be available to
contention
the,
to the existing contractors.
so that is perhaps in clause 26 of the agreement.
Correct. I'm deeply obliged by it. It is clause 26 of the agreement.
Yes, then
So then there was a subsequent tender, and there has been a discovery of price, which was more than what was paid to me under my contract.
yours
So,
was
Bernard,
5.6 and they have been paid 8 something per bed.
Correct, my lord, 8.5, my lord. So I said, well, our contention in before the writ court was that you are giving 8.5 to other agencies, and me, in terms of clause 26 of the contract, I am entitled to 8.5.
Yes.
So, with this, we went before the writ. Writ court passed an order held in my favor. So, and it said, interpreted clause 26, and it said that we would be entitled to 8.5. However, along with that, the writ court also directed the state respondents to consider and dispose of by an order the representation, and it further said that I would be entitled to the
Where is
price
that
variation.
declaration by the writ court?
Yes, your lordship will
Which
kindly take
paragraph?
page. It starts at page 294. And the operative portion, your lordship will find at page 296.
296.
Yeah, but if I may just start from 295, it will become clearer. But can we
No,
take
where is
page
that
290?
finding or that declaration that you are in?
I will come to that, my lord. Allow me to place first page 295.
295, yes.
Yes, my lord. My lord, kindly take the first paragraph starting at page 295. Learned counsel appearing for the petitioner seek to lend the interpretation to such clause to the effect that the nullity contemplated therein would be only with regard to the rates. It is submitted that otherwise the contract between the petitioners and the respondent authorities is continuing. However, despite there having been finalized fresh tender rates, subsequently, no effect has been given to the same vis-a-vis the petitioner. It is argued that in terms of clause 26, the petitioners on an equal footing with other bidders who have been given subsequent tenders is entitled to the fresh finalized tender rates. Learned counsel further points out several representations have been given by the petitioners, most recently in June 23. Then, a perusal of the materials annexed to the writ petition clearly indicates that the respondents being public authorities and work in question being directly related to the public interest, respondents ought to have acted with a more transparent footing. Thereafter, contract, in as much as clause 26 of the contract clearly provides, kindly make a note of this, my lord, clearly provides that in the event of fresh tender rates being finalized, the same would be given effect to in respect of the petitioners. Then, as such, WPA 1315 is disposed of by directing the respondent number 2, that is the Health Secretary, Department of Health, West Bengal, to consider the representation of June 6, 2023, if necessary, upon giving hearing to the petitioners, and to dispose of the same as expeditiously as possible, positively within 3 weeks from the date of communication. Then, kindly, my lord, allow me to place the next paragraph, which is, according to us, the declaration. Upon such consideration, the current finalized tender rates shall be made applicable to the petitioners, if necessary, by modifying the contract with the petitioners and or novation of the contract on such terms. Such effect from the date of publication of the finalized tender rates shall be given as expeditiously after the disposal as possible, preferably within a month from the date of consideration of respondent number 2. Well, now, my representation was required to be considered. They don't do it. And they also don't give effect to the subsequent paragraph, which is at page 296, immediately after the paragraph which records that the manner in which my representation was required to be considered. So I file a contempt. But in the contempt proceedings, they come and file a compliance with affidavit of compliance. Well, kindly take the trouble of taking the affidavit of compliance, which starts at page 301. I stand corrected. It starts at page 310, not 301, 310.
310.
Mile. It starts at the affidavit your lordship will find from 311. And in the affidavit of compliance, they annex a order which according to them was passed based on consideration of the representation. But that your lordship will find at page 316.
Just give us a few minutes just to go through it.
My lord. Fine.
Yes. Please unmute.
Sorry, my lord. Sorry. Lord, kindly take page 316, which
Yes,
is a part of the compliance affidavit.
yes.
And my lord, kindly turn to page 317. Is that at the top of page 317, the petitioners demanded enhanced rate of 8.5 stroke 8 per bed per day with retrospective effect from December 29 with an argument that those rates were allowed for other two such and such operators who were selected through the tender process of 2019. The other two operators such and such being L1 bidders were allowed the tender derived rates of 8 and 8.5 per bed on the basis of an agreement executed with them. It was a contract. She will kindly give me a moment. I stand apology. So the other, will not kindly allow me to place this paragraph once again. The other two operators, namely such and such, were allowed the tender derived rate of 8.5 and 8 per bed per day, and on the basis of an agreement executed with them. It was a contract between two parties, and that cannot be applicable for the third party who had not qualified for that tender. Old tender rates cannot be given post facto approval for a third party who was not stood as L1 bidder at that time and so was not awarded the contract. So this is the stand of the state. In our contention was that this stand of the state is otherwise wholly inconsistent to the specific directions given at page 296, the third paragraph. Now, my lord, in the contempt proceeding, the honorable judge, if your lordship can kindly see the impugned order, puts me in a position worse than what I was before I filed the writ. The learned judge now, in a contempt jurisdiction, interprets the compliance report and effectively, my lord, in my respectful submission, has modified its order of 26th of June 2020. So, my lord, at best, my lord, the honorable judge could have said that does not, but this is not an act of contempt, or or could have come to a conclusion that this is not an act of contempt or this is an act of contempt. Either ways, would have either allowed my contempt, issued a rule, or could have rejected. The Malad, interpretation of the order based on a compliance report, it could have said that the order has been suitably complied with. I'm satisfied that there is no violation of the order complained of. Well, now the interpretation given to this compliance affidavit is inconsistent with the order of 26th of June by which the writ petition has been disposed. Now, Mala, I have been put in a position now that this order of the state, which I've just placed before your lordship at page 316 and 317. Now, this interpretation, now my subsequent cause of action based on this order, my lord, also stands rendered nugatory because of the interpretation given by the honorable judge in course of the contempt proceeding. My lord, kindly take the impugned order once. Well, this would be the order of 6th September 2024. Your lordship will find this with the memorandum of appeal.
So this, the writ proceedings has been disposed of.
Yes, well, the contempt proceedings have been disposed.
No, the writ proceedings where you say that.
Yes. Writ proceedings were disposed of by that order ballot, which is at page 294, 26th of June 2023. Well, then contempt, then compliance affidavit. Based on the compliance affidavit, my contempt was already pending. The contempt application has been disposed of.
Yes, so now you are referring to the order disposing of the contempt.
My lord, which is impugned before your lordships now.
Yes.
My lord, kindly take, this is the order of 6th September 2024.
Yes.
My lord, kindly take paragraph 3. My lord, paragraph 1 and 2 records that, my lord, we filed a contempt against the order of 26 June. Then at para 3, this was our contention. It is contended that although the alleged contemner has passed a reasoned order, the same amounts to tantamounts to violation of the order of court. Counsel for the alleged contemner places reliance on the compliance affidavit to argue that in its reasoned order, the alleged contemner has clearly stated that the two operators were allowed such and such rate based on the agreement. Now, may not kindly take paragraph 8 at the bottom of page 16, which is part of the memorandum of appeal. Now, the learned judges, para 8, it is submitted on behalf of the alleged contemner that as such there was no violation of this order, since effect was given from the date when the revised rates were being made. Upon a careful perusal of the documents annexed to the contempt application, this court is of the opinion that there is substance in the contention of the alleged contemner. It was a plausible view that the revised rates were applied generally across board only by virtue of the order of 30th June 2023 issued by the Health Department. By the order of 30th June, such effect was given from 1st June, that is precise date from which the effect has been given to the revised rate. The argument of the petitioner is that the document at page 172, which is now at page 249, that similar rates were applied in respect of other tenderers much prior to 23, that is in the year 2019, as such effect ought to be given in respect of the petitioners to have the revised rates from 2019 itself. However, the caption of the document at 172 clearly indicates that the same is in terms of FD order of such and such group. Then it says of successful bidders accepted the department. Hence, it is prima facie evident that the said rates were given effect to in respect of particular successful bidders. In terms of the specific agreements, there is prima facie justification in the reasoned order. Then, my lord, kindly take para 15. The applicability in terms of the order under contempt thus commences on and from the date of the revised rates. And it says that the revised rates, although given effect to from by virtue of the order from 30th, takes effect from the order itself from 1st June 2023.
So 17 and 18 is the conclusion.
Yes, brother. So effectively, what the learned judge had held in the writ petition at page 296, that I was entitled in terms of clause 26 to the rates from 2019. Today he interprets that in a contempt jurisdiction. Well, to say the least, well, this order is beyond the contempt jurisdiction. So, well, this order, well, there is a substance jurisdiction issue here. In a contempt, well, it is not open to the learned judge to interpret the order to come to arrive at a conclusion which is inconsistent with what has arrived at the time of disposal of the proceeding.
So according
I'm
to
quite
you, the writ petition order is to the effect that it is to be given retrospectively.
by interpreting clause 26. Yes, madam. And this is what has been held at page 296.
Although there is no, so the honorable judge has not even used the specific term retrospectivity.
Absolutely right. If your lordship will see, if your lordship considers the order by which the writ petition was disposed of in entirety, where the learned judge first records the submissions of the counsel appearing on behalf of the petitioner, records clause 26, and then records that there are other bidders who have been given the rates, which has been discovered in
But
2019 and
the court's concern in a contempt jurisdiction is only the specific direction which has been passed.
correct.
And the direction according to you is in the third paragraph of page 296.
Absolutely.
Which in a specific term says current finalized tender rates.
Absolutely.
And the judgment is being passed in June 23.
Correct. And the discovery of prices, which according to them is applicable to me, was on 30th of June after this order. Basically, that is what they did in order to render this order nugatory and to circumvent the effect of this order, but they immediately published it after 4 days. So, now the learned advocate general has taken a preliminary point of maintainability. He says that no appeal is maintainable. But in view of section 19 of the Contempt of Court Act, is their contention that unless there is a
Order or
Order of-
direction to punish
For
for
punish-
contempt. That is
punish
the
for
expression
contempt.
under section 19 Contempt of Court
Correct.
Act.
Contempt of Court Act,
Contempt of Courts Act.
no appeal is maintainable. But there are two judgments of the Supreme Court, and there is one division bench judgment of the Calcutta High Court, which interprets the two Supreme Court judgments, and says that there is a judgment of 74 Supreme Court and there is a judgment of 1988 Supreme Court. Well, 74 judgment is 1974 Supreme Court 2255, and the subsequent judgment of the Supreme Court in Taneja's case is 1988 3 SCC page 26. Now, Calcutta High Court, well, in 96 Calcutta Weekly Notes, consider, this is in the year 1991, considers
You
both.
have your junior is having any copy of these judgments for the court or?
Well, that is the difficulty that we are facing today. Well, there has been some communication gap with the.
But on your request, we had fixed it, we had adjourned it on the last 2 dates, and still if this difficulty persists, then we don't know how to deal with the difficulty.
Well, apart from apologizing, there is really there is nothing that I can say right now. Well, this has been extremely unfortunate. I can understand, but the council doesn't have the either the soft or the hard copy of the judgment which I wish to rely upon.
How do you propose that we should consider it then?
Would it be a lordship pleasure that if your lordship takes it up at or tomorrow, first matter tomorrow, then I
Give
can
us copies of the judgments that you are relying
I
upon.
will. I certainly will.
You ask your instructing counsel here to give us copies, we'll keep it tomorrow. Mr.
Deeply
Datta,
obliged.
it is all right. Tomorrow we have it.
Well, it's okay for me. Only thing is, Millard, if Mr. Bose can give the citation of the third judgment that he wanted to refer, 96 CW and the page number.
Perhaps you want to
96.
have the benefit of being in the same place that he is.
Yes.
He will give you the citations.
Very well, very well. Very well, very well.
You please, Mr. Bose, you ask them to give us also copies so we can consider it.
Certainly, Malad, certainly, certainly.
For further submissions on behalf of the learned counsel for the appellant, the matter is adjourned for the day.
Well,
Yes.
Obliged, Malad.
I'm grateful. Millard.
Yes.
I'm grateful, Lordship.
Who is appearing? You are appearing? You are appearing in this case. We have just adjourned.
Yes, yes.
Please give copy
Lordship.
as soon as possible. Yes.
Millard, I am appealing for the appellant.
Yes.
Millard, on the earlier occasion has already considered the impugned order that the appellant was seeking a fresh registration under the GST Act. And Millard, the fresh application was rejected entirely on the ground that there was an earlier cancellation against which he has not preferred an application for revocation. Millard, the Honorable Single Judge has granted an opportunity to us to file an application fitting the same as an application for revocation within a stipulated time
State
period.
GST.
State GST, WBGST. Against that order, Millard, we have preferred this appeal principally on the ground, Millard, that even though there is a provision for revocation of cancellation under the Act and the rules,
Where is the impugned order?
yes, it must be with the memo of appeal, Millard. This is a 3-page order.
Yes.
Yes, so Millard, we are aggrieved by this order only because of the fact that my earlier
What
cancellation,
period did you not carry on business?
Millard, 2018 onwards.
Means till
Millard, 2018 onwards till Millard 2022.
when you applied afresh.
Then I filed afresh in 2024. And my earlier cancellation
Don't
was in
say till
2017.
22, then till 24 you did not carry on.
Yes, 20,
23,
Even-
23, 24 is the,
even 23, we had nil turnover.
so wait. 23, 18 to 23, you said there was no business. tax.
No business, no business.
So there is a provision in the act that when there is no business, no return is to be filed.
No return is to be filed.
Let's see, where is that?
Yes.
Let's see.
The Miller kindly considers Miller under the GST Act,
Yes.
the relevant rule, that is Rule 9.
Yes.
Before Miller goes into the rules, Miller just one line of submission so that Miller looks at it in that way.
The way you want us to.
No, Miller, that's of course it will be my desire always.
I guess.
So far as the rule regarding registration is concerned, what are the
We are not on
factors?
registration, see, 18 to 23, you don't file a return.
That's right.
You
Now, when
say
I make
didn't
a,
file because there was no business, why can't I be given a fresh registration?
that's right. Now, Miller, when
So
a
there-
fresh
anyone who
application,
does not file a return, it should be presumed that he is out of business.
no, Miller, because my registration was also cancelled earlier.
The point is, when a person does not file a return, the authority should presume that there is no business.
Miller,
Can it be done?
generally, Miller, it has to be so.
That has to be done, or they will proceed against you why you did not file a return.
No, when they cancelled my earlier registration, upon examination of my financial records,
Can-
Miller, after examination of my financial records,
Taxing is statute.
yes,
Remember,
yes,
the area which we are considering, it's a taxing is statute.
right. So the primary concern,
Strict compliance.
that the primary concern would be whether the revenue is facing any loss.
He knows when you don't file a return.
That's why, Miller, I'm saying,
That is the issue.
Miller, in 2017,
For
Miller-
18, 19, 20, 21, 22,
Miller,
23.
I have stated, Miller, in my appeal,
That is enough.
Miller, in my, when they cancelled my registration,
Yeah.
my fresh application and they sought for clarification,
Yes.
I have clarified by stating my returns which have been filed under the Income
Let us
Tax
see
Act.
what is the provision. We
Yes.
cannot go by your
Yes.
clarification.
Yes,
Whatever is the provision.
I
they have to be
will,
strictly complied with.
I will take your lordship one
Yes.
by one. Miller would first take Rule 8. Rule 8 of the WBGST rules. Rule 8 deals with Miller submission of the application. And Rule 9 is relevant for us, that is verification of the application and approval.
You are jumping straight to application for a fresh. We are asking you what are the consequences of non-filing of return.
Miller, the kindly take section 29.
Yes.
Section 29 deals with cancellation of registration.
We are asking you what is the effect of non-submission of return.
Non-filing of returns, Miller, will result in cancellation of
Let us see,
registration.
where is that?
29. The proper officer may either on his own motion or on an application filed by the registered person or by its legal heirs in the case of death of such person, cancel the registration in such manner and within such period as may be prescribed, having regard to the circumstances where A, business has been discontinued, not our case. There is change in continuation of the business, not our case. C,
So 2B.
2B. So C and then 2.
Yes.
May cancel the registration of a person from such date, including any retrospective date, as he may deem fit, where a registered person has contravened the provisions. B, a person paying tax under section 10 has not furnished returns for 3 consecutive tax paid. B and C is relevant for us. Other than a person has not furnished return for a continuous period of 6 months.
No, B is 6 months, it's much more than 6 months.
Yes,
It is even more than 3 years.
60 months.
yes.
Yeah.
Now, Miller, this is the ground on the basis of which they have suo moto cancel my registration with a retrospective date.
And then 29(3).
Yes, this is where I am also because Millard is conscious that in a taxing statute, The primary concern whether there is any loss to the revenue.
So how this
Now,
is to be
when-
determined? Just
when-
because we make an application, they should.
Milord, while cancelling the registration,
Yes.
they are also equipped with all my financial data to verify what was my business turnover during that period. Now, while cancelling, they did not raise any claim of tax. It was a simpliciter cancellation, but Milord must have considered other cases where at the time of cancellation, tax, penalty, interest, everything is being charged if there isn't a due liability. In my case, there was no due liability. It was a simpliciter cancellation only because of the fact that there was no business turnover. And I did not file a return. Now, Milord, in 2024, when I prefer an application for fresh registration,
Can you do so overlooking section 30?
Milord,
Can you just skip section 30 because you want a fresh registration?
Milord, I am not skipping. I am only saying,
So what have you done under section 30?
Milord, I am only saying that apart from prayer for revocation of cancellation, there is no bar under the law in granting a fresh
No, but
registration.
section 30 is a specific provision in the statute for revocation.
Right. Now, Milord, kindly look at it from a different angle.
Yes.
A
So
person,
according to you, it is up to the SSC. He can either.
no, not up to the
avail
SSC.
30 or he cannot avail.
Cannot be.
Cannot be.
Because when you are cancelling my registration for non-filing of return,
For whatever reason.
For whatever
there is only
reason.
one thing you can do, that is revocation.
Milord,
There is no other option under the statute.
Milord, subject to correction, Milord, kindly advise the situation.
See the fresh application for a new registration.
Yes.
Where does it anywhere mention that one who has earlier had a
No.
registration, he can resort to that?
Milord,
It does not.
is
Yes.
under Rule 9,
Yes.
when a fresh application is made for, let us,
When fresh application is made by a fresh assessee,
right.
not by an erstwhile assessee.
When I made this application,
Yes.
they are supposed to even consider my next application, the fresh one, in 2024. When I made this application, they considered it under Rule 9 of the rules as if it is a fresh application. They considered it and they sought for clarifications.
So what
And one clarification
right
sought,
does that vest in you?
one clarification, my
That
only.
is a routine and routine manner that is done in every application.
Right.
that proceeds. Now.
Right, they
everything is-
sought a
now
clarification.
everything is on the portal. It
Milord,
is more or less automatic.
Milord, they sought
All
a
this process,
clarification. Milord,
yes.
they sought a clarification that your
That will not create
registration-
any right in you to claim a fresh registration.
No,
After undergoing that exercise, they say you are an erstwhile SSC. Why you can't, why we should not resort to 30? And
Milord,
why you should go
The
for a
only
fresh?
reason is,
Yes.
Milord, is a practical difficulty which you lot
That
must
cannot be
consider.
considered
Milord,
in a taxing statute. Therefore, at the outset, we told you
Milord,
that
kindly
this
see
is a
this.
taxing as statute.
Milord, right.
There is no scope for all this.
Milord, at the same time,
Yes,
Milord, a bona fide taxpayer,
we don't know.
once he is out of business
We
for
don't
6
know. We
years,
don't know.
now, Milord, if you revoke
You
my
cannot
Milord, if you-
overlook section
Milord,
30, sir.
Milord, if you revoke my application, if you revoke my cancellation, the consequence will be I am required to pay late fees for 7 years for which I have not done any business.
That is precisely what you are trying to avoid.
Exactly, that is the reason I prefer the appeal.
So whether it
My
can be
only
allowed,
question-
whether
Milord,
it can be enforced by issuance of a writ.
Milord,
Please.
Milord,
Please show us one law.
Milord, I am only saying this.
We are not on practical difficulties. Again and again, we are telling you, you are not arguing a writ petition of under another law. It is a taxing statute. In this statute, there is scope for issuance of any such direction.
Milord, the statute at the same time does
Can't
not
be.
bar, does
Sorry.
not bar grant of fresh
That we have said
registration.
sufficient number of times. We have heard that.
Yes.
That we have heard. We will
Let's-
consider whether there is no bar or no bar.
It does not. It does not.
At the same time, can you overlook section 30?
So my only consideration
That is the only thing.
My only
So
consideration
according
is-
to you, section 30 means nothing.
No, it
It's
means
up to the
something.
SSC.
It means something when there is an explicit violation of section 29.
Oh.
I have not violated anything save and except that I failed to file my returns.
That is a
also
violation.
justifies-
That itself is a violation.
Now, Milord, if someone doesn't
B,
have a business,
B2C and what is it, the provision? 2B
29.
and 2C.
29.
2B and 2C
Yes.
are two lapses based on which it can be cancelled. What are you saying? There is no default. These are two lapses under which it can be cancelled.
Milord,
And therefore it has been cancelled.
it starts with a person who is paying tax, who is liable to pay tax.
All right.
See, if someone is out of business and does
Very well.
not pay tax,
All right.
whether Millard it should be a contravention, and for
Okay.
7 years, if my application for revocation is considered and it's Millard a substantial amount of fee, which I'm required to pay. Millard, under 226, Millard, this court has the power to go and
Oh,
weigh
yes.
whether the
Give us
statute,
one, again, we are asking you.
Millard, on this point, Millard, there is no
Sorry,
judgment.
you
that
will
is
not
taken.
find, sir. That is why we are asking you. You will not find.
And only Millard subsequently in
Yes.
2019 by way of a departmental practice direction, they have said that cancellation of revocation, cancellation of registration earlier will be deemed to be a deficiency under Rule 20 or Rule 9. Will be deemed to be a deficiency.
Where is the
Now, Millard, I asked myself,
that deeming that is a notification.
notification.
Obviously based on 29.
No, not 29.
Has to be,
Will
it finds its foundation in 29.
Now,
It has to be based on 29.
Millard, I asked this to
You
myself.
please show us the notification.
Yes.
It has to be based on 29.
তোমার অ্যাপিলেট অর্ডারে রেফার করা আছে।
Section 29 is in the opening line. What do you say?
No, no, Millard, can we see?
You see.
No power under 29 has been issued.
It is, see, the
That's a
power is not
file.
required to be exercised. There is no power required for issuing this notification.
It is
The
required.
lapse is contained in 29.
168
Relying on 29, this notification has been.
Under 168
Not-
A, a notification can be issued. Can a
Alright.
notification?
You have not assailed this notification.
I'm not.
Therefore, we are not going to enter into that
No, no,
debate.
Millard, they have relied upon it.
Maybe they,
The appellate
they
authority,
may have.
while rejecting
The
my
point is
application.
whether you can seek a fresh registration or not. That's the only issue.
Millard, there's no bar in the statute.
That you have said a sufficient number of times. That we'll consider.
Yes.
That's-
I will kindly seize this. The last portion. Large number of registrations has been cancelled by the proper officer under the provisions of subsection 2 of section 29 of the CGST Act. Hence, Millard, it goes on to say that their clarifications are required to be given. Para 4. The second line. It is clarified that not applying for revocation of cancellation of registration along with the continuance of the conditions specified in clauses B and C of subsection 2 of section 29 of the CGST Act shall be deemed to be a deficiency within the meaning of subrule 2 of Rule 9 of the CGST rules. So prior to this, cancellation of an earlier registration was never a ground for rejecting a fresh application. It is only by way of this clarification they have inserted that your earlier cancellation will be deemed to be a deficiency. Otherwise, it is not there in the rules.
That's all.
I'll just rely on one judgment. Notification cannot substitute the rules.
We are not going to look into the notification.
So, can this be a ground? If it
So-
is not there in the rules,
Then we'll see.
let
We'll decide that.
Can you say 30?
You will never
I have violated
accept that
section
it is a valid ground.
I have violated section 30.
Your lapse to submit a return
I have violated
is
section
itself
30.
a ground for cancelling.
Right, my application
Therefore,
is
whether
cancelled.
this notification is applied or not,
No, Millard.
it is hardly material in your case.
Millard, it is Millard. Kindly, Millard, subject to correction, Millard, kindly consider this once again.
No, sir.
Under section 30, I have done a violation. The consequence is my registration
Under
will be
section
cancelled.
29.
29, I'm
Not
sorry.
30.
29, I'm
Yes.
sorry, Millard. 29, I have done a violation. My registration, the consequence is my registration shall be cancelled.
Very good.
They have cancelled it. Now, Millard, I have two remedies.
That you say.
Yes.
We are unable to agree with you.
Millard,
We are being very clear
Millard, kindly consider
that
this.
we cannot overlook section 30.
Millard, kindly consider this,
We
Millard.
cannot.
Millard, kindly consider this.
Yes.
After Millard, my registration is cancelled.
Yes.
Revocation is provided in the statute,
Very good.
and applying for a fresh registration is not barred by the statute.
That, how many times you'll repeat the same thing? Does it make the point better by saying it 10 times? It
And
does
Millard,
not.
The rules, Rule
Yes.
9, which talks about considering fresh application,
Very well.
never said that your earlier rejection will be a deficiency,
Yes.
which they are trying to supplant by way of a notification, which according to me, Millard, cannot be done.
Very well. Tomorrow for orders. Heard the parties.
Millard, only one judgment, Millard, that notification cannot substitute the
We are not
rules.
going to
It's
rely
not
on the
required for my satisfaction, Millard.
We are not going to look into the notification.
Careful.
Send this file then. In the chamber.
Number 7.
Yes, what is this?
Oh, this is my position, my lord. I was the writ petition.
You are the respondent here.
Writ petitioners.
Yes, what is the issue?
I have a preliminary objection, my lord. Regarding maintenance appeal.
Yes.
I believe that.
This arises out of writ proceedings. So what is the objection on maintainability?
I just, if you lost shield. Your Lordship, kindly, what happened? Your Lordship, kindly, I want to be, Your Lordship, kindly come to pay for a moment 20 the stay application. However, I preliminary objection that, my lord, I have challenged in the writ petition, I have challenged the order of the Mayor in Council. And Mayor in Council has given me, my lord, sanction of building plan, of payment of fees.
We are asking you on the point of maintainability. We are not asking you to argue the case. You said preliminary objection.
That application is paper of the commissioner himself, and I challenge the order of the Mayor in Council, he has been implemented as a performer respondent.
So there is an issue of maintainability.
But you also I am agree. I challenge the order MIC. That order has been not set aside. Directed by the writ court to consider further resolution. Now
Directed who to consider?
MIC.
Yes.
Now the only commission has favored the appeal.
So
The name of the corporation. MIC has
he
been.
was not a party to the writ proceeding.
Oh,
Commissioner,
yes, yes. But here, my let's see,
then where is the issue of
Yes.
maintainability?
MIC should not be as a performer.
We are not on merit, sir. He was a party to the writ proceedings.
Yes,
He is
Commissioner-
entitled to challenge the order.
You
Where is the issue of maintainability?
You also appreciate. Or I'm trying to
You may argue later. Yes, sit down. Yes. No issue of maintainability. Yes.
Lordship takes up the impugned order.
Yes.
Now, what had happened, Lordship, the respondent here, Modak, he submitted a building plan before the Siliguri Municipal Corporation for sanction.
Yes.
Now, before he got sanctioned, before the plan was sanctioned, he started to raise construction. This was pointed out to the corporation, and accordingly, corporation verbally asked him to not to proceed with the
What is the procedure?
Yes.
Where is the procedure? Show us the procedure. Once the mayor in council has given the approval and on that basis they have proceeded, then what is wrong?
Yes.
Where is show us the provision under which the mayor in council gives the approval. Who is the competent authority? Show us. He proceeds on a approval given by the MIC and then you proceed to demolish.
No, there are things which have happened between that.
So therefore, whether the MIC's approval has any value or not under the statute or under the provision, where show us whether he is authority, whether he has the jurisdiction to do it. If he does not, then why not? Where is the provision? That is all. Let us see.
Section 41 of the West Bengal Municipal Corporation Act.
Yes.
One.
41. Where is the Municipal Council Act?
Powers and functions of municipal authorities and officers of 41. Powers and functions. 41.
There is any delegation under section 47 to the MIC? Is there any delegation of power under section 47 made by the Board of Councillors?
Yes, generally the building plans are considered by the mayor and council.
So there must be a delegation
Yes.
under section 47.
This is what is happens. Generally, when the plan is submitted before the commissioner for approval, it is sent to it is placed in the meeting of the building committee. Therefore, thereafter it is placed before the.
Which are the relevant provisions? Can you please give us? At least speaking for myself, I would like to take the opportunity to understand the scheme of the act.
Gotcha. So also current is of section 275.
275.
Yes. This is the approval of building sites and sanction plan for erection of building. No piece of land shall be used as site for erection of unless the site has been so approved on payment of. This is the.
275.
275, this is the approval of building sites and sanction for erection of buildings. Thereafter, I will request your lordship to come to page section 263, that is the sanction or provisional sanction or refusal of sanction for erection of building of.
260?
3.
275 and 263.
263 says that the commissioner shall sanction the erection of a building or execution of a work unless such creation of building or work would contravene any of the provisions of subsection 2 or subsection 3 of this section or the provision of section 289C or 289D, provided that no such sanction shall be accorded without the prior approval of the mayor and council. Without the prior approval of the mayor and council. No.
263, just a minute.
263.
These are the only two relevant provisions.
This is the powers when the commissioner will pass a building plan upon the prior recommendation approval of the mayor and council, and if your lordship takes section 260, that is the municipal building committee.
So prior approval is required.
Prior approval of the mayor and council.
Then they have got the prior approval. They have not got.
What has happened is that they placed a building plan for sanction. Now, before the plan was sanctioned, ultimately authority is the commissioner who puts the signature.
You said they have no prior approval.
coming to it.
Where have you said that? That they have no prior approval? Show us
Yes.
your averment that they have no prior approval under 263.
Your lordship. Your lordship, kindly take a turns to page number 22 of my stay application.
Yes.
Paragraph number 4. This was the meeting of the 28th Mayor Council. Page number 22.
You just now said they had no prior permission. Where is that averment that under 263 they had no prior permission? Show us this averment. You have just said it. We asked you a specific query.
Lordship.
You said no. Show us that you have taken this stand. This is a factual submission. It must be founded on pleadings.
Lordship.
So where is that? Let us see where you have said so.
Your lordship takes paragraph number 11.
Read where it says 263 prior permission was not there. Read it.
Now, may I read from paragraph number 8? In such conspective of facts, the matter was placed in the meeting of the building committee, which was held on 10/11/2023. The findings of the said meeting are as follows. As per site inspection report, the construction.
We are asking you to show that averment that there was no prior permission by the MIC under 263. Just now you said no when we asked. Oh, where is that averment? How can you make a factual submission without any foundation in the pleading?
I'll be demonstrating from the document.
We are not asking you to demonstrate the legitimacy of the process. We asked you a specific query. Under 263, they had a prior permission of MIC or not. You said no, which is a statement of fact, not for the council to say off the cuff. We are not oblivious of the fact that there is some internal, something going on in all the corporations. For that, the person should not be noticed.
No,
Don't make such submission on fact which are not there in the
I'm not
record.
making a submission on fact, but
You have made,
but
you have made a submission of fact which was not there in the record. Please don't do that with the court.
Lordship.
Let us come back. You show us where you have said.
Lordship.
All submission are not appreciated at all.
My lord, criminal matters, I hope, my lord, we're not reaching the criminal matters, then we'll be taking off matters.
Today,
Today, no,
which.
because lot of civil matters are there, no, after the appeal matters, appeal hearings are there, my lord.
There was
Then,
criminal matters also before DD.
yes, my lord,
Appeal.
the last,
At the end,
at the end, my lord, hopefully, I think, lot of civil matters are there.
91. Think you are that fast.
Then, my lord, we'll leave, my lord. Grateful, my lord.
It's confirmed.
Yes, confirm. Because confirm, he is not there, so he has, right, so.
Both the courts over by the so. You close it.
My lord is sitting in. So.
My lord, may I submit one thing, my lord? So that this continuing matter and the next matter is identical in nature. Arises from the same notification, my lord. My lord, let it be tagged together and I'm here, my lord, in the next matter, item number 8, my lord.
So we hear you, don't worry.
My lord.
Where is the impugned order of the commissioner? Which page?
Page number 26, of the stay application, 25.
Page?
Page 25. Page 25 is the order of the executive engineer cancelling the thing. Page 27 and 28. Mayor and council.
No. Where is the commissioner's order?
Page
28.
28 of, yeah.
This is not the order. Where is the order for demolition?
Whereas in April now in comes. You are hereby directed to demolish the another structure.
This is the impugned order.
Yes, page 28. You go on 26 one. This mission of MIT.
Third October 24.
Third October is the single. Third October.
No, this was to take effect on 3rd October, 26/9/24.
Yes.
And it refers to earlier rejection order. Which is the earlier rejection order?
Rejection order is 26. The rejection order that page 24. This is the clarification which is the corporation has sought for, and the Department of Urban Development and Municipal Affairs had given the clarification.
And where is 1811 order?
1811. Page 20 also.
Respondent's name is Abhijit.
Abhijit Moto.
So this is this order which has been passed in the minutes in the meeting of the mayor in council. This is subject to review by the commissioner.
So it's been reviewed by the mayor in council itself.
Mayor in council himself.
Itself it has been reviewed. We lordship edit page number 22 was reviewed in the month of April.
Page 22.
Page 20. This is the postings of the 28th MIC meeting, paragraph number 4. Where the decision was taken to seek clarification from the UDM department. Pursuant to this decision, the commissioner has sought for the clarification.
What is SMC?
Siliguri Municipal Court.
This is also MIC.
MIC, this is also MIC, and the other one also MIC.
So what is the time between the two meetings?
This was
1811 and this is
April.
April.
March. April. 27 April. 4 months.
No, nearly 6 months, nearly 6 months. That is 18 November, nearly 6 months. Then after that, what happened
When this decision was taken,
by the MIC?
this decision, the given lodging touch the next page number 23, the commissioner SMC had sought for a clarification from the state government. Subject is seeking necessary clarification in regard to commencement of construction work before getting the building plan approved in the web portal through OBPS.
And then again, there is an MIC meeting on 19/9, 24.
Yes.
And where is the consideration about his case? This is the one page, this page is only dealing with his case.
No. That's the relevant
So this page is dealing with,
paragraph number 3. Letter was sent to the Joint Secretary, Department of Urban Development and Municipal Affairs, Government of West Bengal, by member numbers of state charge, informing that once Abhijit Moto of Ward number 10 and applied for approval of his building plan to WPS OPS portal, and the same was passed in the MIC meeting held on 18/11/2023, and subsequently in the Board of Councillors meeting held on 29/11/2023. However, it came to the notice that the applicant had constructed some structure of the same plot of land before obtaining sanction building plan. The BOC meeting held on 30/4/2024 and decision was taken to refer the matter to the state government seeking necessary clarification of this regard. The similar case was also referred. This the next one is regard to the next Rajiv Shukla.
Yes. So there is no provision for post facto sanction or approval.
And the West Bengal Municipal Commission.
Then how this MIC took a decision in this meeting of 18/11/23?
Now, Lordship. What the 2006 Act says that if there is if there is a provision, they try to borrow a provision from the Kolkata Municipal Corporation Act. Now, for that, this 2006 Act says for that you need to take prior approval of the state government. The state approval of the state government.
Oh, but there is a decision of the MIC on 18/11/23.
Yes, this I admit that this was a wrong decision. This was a wrong decision.
But on the basis of this wrong committed by you, he has parted with nearly 1 lakh rupees. And he has,
Subsequently, we have given him a letter to take back your. That letter is also on record.
plus the MIC takes note of the fact that it is maintaining the WBMB rules.
Yes.
So if there is no infirmity, then merely because it is without prior sanction, therefore. What is WBMB rules?
The original municipal building rules.
It is in this book.
No, madam, separate.
So it is according to the building bylaws.
This period. Only thing is that there is no scope for prospective advice. We are in council meeting. It got stuck in the subsequent meeting of the building.
So what is the structure is only up to plinth and few columns.
Yes.
What is the point in demolishing it now? You make a measurement.
Gotcha.
You are ascertain that it is in accordance with WBMB and you proceed accordingly.
To that, I'm being fairly certain that it has already been done, it is in accordance with the.
Then why unnecessarily that will? We understand that the statute requires
Yes.
that there must be a prior sanction.
The court directs. This is action from honorable court, which has
It is. Not the building plan. But the point is, what is in the next case?
Well, next case is
Thing, only in this case.
In the next case, only money has not been deposited.
Both stand on the same.
the money was ascertained, my lord, money was ascertained. When
You are
I
not
went
appearing
there,
in the other case. Yes,
in my case, money has been ascertained. And I was asked to deposit the money. When I went there, they said, no, we cannot take. But in Abhijit Modok's case, they have taken the money. Only difference is that everything is identical.
but there is a decision of the MIC in the other case also in his favor. Can we see that file? Let's see it. Next.
Same meeting of 18th of November.
18/11/23. Say, oh, it is
Yes,
in
yes,
the.
same,
It's a
same,
composite.
everything
It's a
same.
composite.
Yes, yes.
Okay. Which page? Can you show us?
Yes.
Yes, it is at page 17.
17 lodge.
Yeah.
As per site made it for the remarks, as per site inspection report, construction of the said building has been commenced. What as per the report, the foundation, beam and column up to the ground floor has been constructed so far, maintaining the rules. Both of them maintain the rules, but difficult to meet with that.
No, my case, Malad, Rajiv Shitlani is the writ petitioner, Malad. The same meeting it has been.
Yes, we have seen the MIC decision is of the
Yes.
same date.
Yes, everything is on the same date, Malad, identical.
Both the matters were actively considered by the Siliguri Municipal Corporation on the same dates.
Where is that provision requiring prior sanction? Let us just see once. 261. What is the?
263, that with 275. Right.
275.
275, it said that no piece of land shall be used as site for erection of a building unless the site has been so approved on payment of fees at such rate as may be prescribed and within the prescribed, and no building shall be erected unless a building plan has been sanctioned for such erection.
So this is the provision which says that there is a prior sanction is required. No, 261A, capital A.
Prohibition of building without sanction. No person shall erect or commence or erect any building executive works specified under except with the previous sanction of the commissioner and in accordance with the provisions of this chapter and rules, regulations of the made under this act, in relation to such erection of building or execution of work on payment of such fee as may be prescribed.
So their requirements are prior sanction.
Yes.
Then requirement is in accordance with the provisions of this chapter and the rules for erecting such building. So according to you, one of the aspect is violated. But prior to commencing work, they had applied for the sanction.
Yes, prior to commencing work, they had applied, but before the sanction, they started.
And what is the period between their application and starting commencing of work?
Yes.
In my case, second case, there was 7 years. I have applied, it has been
Applied
recorded
for
in the order.
first matter.
Yes.
The first matter, application was submitted on the OBBS portal on 20th April 2023.
Yes.
Then on 27th April 2023, the deeds were verified and marked as appropriate by the deed checker. Then on 28th April, the architectural plan was recommended by the sub-assistant engineer. On 7th May 2023, the building plan was approved for submission by the assistant engineer. On 22nd May, the design was verified and confirmed by the executive engineer.
So all the process was done.
All the process was ongoing. Now when the plan is submitted, the deeds will be checked, the inspection will be made. Then it will be placed before the meeting of the. Now the day on which it was placed, it was found that they made some amount of construction. That was it got halted.
In both the cases, the
Both the cases-
timeline is similar.
No, in my not similar, but I have made in my stay application I have made the timeline, the synopsis page.
So the
Synopsis
first
and-
case application is 24-23.
20th April 2023.
Yes.
And in the second appeal,
2022.
they had applied on 16/8/2021.
21.
21.
Yes.
And no sanction was accorded till
Well, in
November
my case,
23.
Surprising enough, my lord, I have demolished dismantled my own building because that has been that has been diplomatic condition and it has to be demolished. I demolished that, and I am erecting new building on my land only. But for that, I am not getting any sanction plan for 7 years. My old
In the second
parents
case
are
also the project, the checking and all has been done.
Yes, yes.
You have said so in your stay application.
It I have said so in the stay. In the stay application, in the list of dates, all the I have made given the relevant dates when what has been done.
All right, we understood, but we are not passing any order right now. I want to see the entire provisions before we pass any order. Not familiar with these provisions. So, can have it on Monday. You need not be here. We are aware of the facts. If you are here, more than welcome.
I will. I'll come.
Otherwise-
I'll come back.
Yes.
My books will be
Sir.
here. Keep the books. Oh,
These-
are the lost books. Oh,
These are our books, sir.
yes. Well, give the building rules.
Yes, we'll get it. Just give the name, we'll get it. For further consideration, list on, give the date of Monday.
Now, the amendment of the rules also, this is minor, you have to say the minor, any minor execution of work with a sanction, that can be in the rules itself. State government has taken.
What?
If any minor execution work without sanction, state government has, the building rules as the amendment has come. At percent.
This will have a retrospective effect. Because you have started prior to November
Then-
23.
Yes.
This is of December 23.
And then my lord, subsequent decision of.
We'll have to see you, if you can come with some judgment on that day. Under such circumstances where there is,
But this will only come into play when he has
No.
ordered a sanction building plan.
correct, then there is a deviation. That is a normal thing everywhere it is.
No, not only deviation.
Unauthorized minor erection.
Execution of any minor work without sanction.
That's what we are saying.
So There is a.
This is not a minor, this is a full residential building which is being constructed.
No, this is only plinth minor.
Plinth for entire building, not just for one.
She said is much more. Only this is.
No, we'll consider, actually, so the admitted position is that procedurally there is a violation, but there is a mistake on both sides, from their side as well as your side. So we'll have to see, but I want to go through the provisions.
My
So
lord,
first we'll,
they are also, they say that they have followed the rule 400 of the Calcutta Municipal Corporation Act.
yes,
Section 273A, they can do it. This is a BP section says, this may be required, my right?
that is section 400 for demolishing.
No, this is a demo, that's, 400 is demolition. This third provision says, in case of minor execution work without sanction, it can be regularized by payment of the fees.
That is there is a provision here also.
No, there is no such provisions.
There is no provision for condoning any deviation
This is now.
under the West Bengal Municipal Corporation Act.
Now these rules has come. It may be relevant. I just.
So how do you deal with if somebody during erection of the facade has violated by a few feet or maybe a 6-inch or 8-inch, it has to be demolished?
No, if that, we first measure it, if it comes within the purview of 5%.
So 5%
now there is
deviation
nothing.
is there, has to be, can't be so
Within
water
Starting
tight.
is.
And if it is beyond 5%, then go.
I'll-
But for that,
Up to 5% condonation fee.
condonation of payment of fees.
With
Beyond that-
condonation fee, beyond that, there is no provision.
Beyond that.
That is a very normal situation, 5% almost. Just- Instead of Monday, keep it on Tuesday.
Right.
Yeah, Tuesday, not Monday, Tuesday.
My lord, can it be fixed at 2 PM? My lord. No, about 2 PM.
Don't worry, it will be taken up.
My lord,
We'll
I'm
keep it at
grateful
the
to
top.
my lord,
We'll
grateful.
keep it at the top. We will keep these matters at the top. Huh? The one we have just taken up. 8, opposition taken on record. Huh? So there is a time limit for considering these sanction plans, or there is no time limit?
Now, the act says that when a building plan is submitted, placed for the corporation for approval, it has to be done within 30 days.
That has been considered by the honorable single judge.
That you have not told us. You also didn't say this.
No, I'm not allowed to explain. My law says I'm 263.
All right, very well.
This is my argument.
We'll consider.
No, I'm not.
It's 30 days or 60 days?
30 days. 60 days earlier, or 30 days. 263(4), subsection 4. It's online application, 263(4). হ্যাঁ, জজ সাহেব লিখেছিলেন। It is recorded in the.
And what is 277?
So. Sanction of building plan and permission to execute work.
This is
Subject to the provision within the period of 60 days after the receipt of application in the building plan or any information or document which the commissioner may require the applicant to furnish before deciding whether the sanction shall be accorded in this regard. The commissioner shall, by an order in writing, either accord sanction.
Within 60 days.
now this is 60 days, online is 30 days.
You are regularly representing the
No, my lord.
corporation. Yes.
Online is 30 days.
All right. So maximum 60 days.
Yes, yes.
Call the next.
Item number 9.
Nine Mallard, in this matter, Mallard, I am appealing for the applicant.
But I appear on behalf of the respondent petition.
My lord, the section 5 application was allowed. Beg your pardon, my lord.
Section 5 has been allowed.
Yes, yes.
Section
Now,
allowed.
it is. The writ application has been filed by on the premise that one can turn to page 42, the order impugned, otherwise I can.
Page 42.
42 of the application. What is the order impugned also this appeal?
You are not in a rush. We hope. We hope you are not in a rush. Yes.
Mr. Sudhashatha Banerjee,
Yes.
this matter
He's here.
Yes, yes, online.
virtually.
No, Miller, I'm appearing virtually.
Yes.
Plus, you can allow me to address the bench.
This is a vast plot of land. According to the writ petition, they have purchased the land. They want demarcation of the land because there is no litigation is pending between the what they have purchased and the parcels where they are residing. On the premises of this matters, kindly turn to page 42. Last paragraph, honor. The petitioner through his learned advocate, Mr. Sumit Vishwas, my lord, got it.
Just let us.
Yes.
This demarcation is done under which provision?
That is a precisely my argument will be before your lordship. There are two provisions are there.
Can we see
Under the
it?
Bengal Survey Act and section 54 of the Land Reforms Act.
That requires an application to be made only by the landowner.
Landowner, apart from that, whether any denial comes within the purview of this writ court. This came up for consideration before the honorable single judge in the for persuasive value, I am placing before your lordship. My lord, if your lordship can turn to there is a single page judgment.
Where is the provision? Where is the provision?
So for the provision, my lord, if you logically consider, this is the, once the government land is involved, there is a dispute between the government land and the private land, there is a scope of demarcation by the concerned BLLO, who has the authority to demarcate the land. That your lordship find under the Land Acquisition Act, as well as the
So
Act
these
two-
are government land?
No. So this is the private land.
So what is the provision?
There is
Any,
no provision, that is precisely, my lord, I have handed over to your lordship, the only provision is section 54 of the Original Land Reforms Act.
can we see that provision?
Yes, sorry.
Please try to understand. You think I know all these provisions?
That has been quoted, my lord, I have handed over to your lordship, my lord.
In this,
Yes, yes, yes. আমি দেখে আসলাম আবার।
in one case, if you show it, then subsequently it will be easier for everyone.
Great, great. Sorry, my lord, it's my fault. It's my fault. May I read out, my lord? In the meantime, my lord, say, third paragraph, the
So you had approached the writ court.
Yes, no,
They had approached
they
it,
had approached the report.
seeking a direction that demarcation be
I
done.
had approached the.
You have opposed that it is not their land. Therefore,
Yes.
they cannot seek a demarcation.
According
No,
to
but
the
Court
I
has
just
directed
indicate-
respond
Malad,
number
may I-
2 to look into the issue. Who is respond number 2?
respond number to the subdivision. SDL, some land and land.
He is the authority for demarcation.
No, that precisely. Challenging that order, my lord, the order passed, some petitions, respondent, approach the honorable division. Earlier also. Because
Malad,
there
am I audible to your
is
lordship?
some persons are there.
We are not asking
No,
about
I
this
can't be
case.
heard.
We are asking about the power and
I can't be
jurisdiction
heard.
of the
Section
SDL.
54, apart from section 54, there is no other provision. And that section 54 precisely in respect of the government land of the original land reforms act. If your lordship-
There is no other provision for
Malad, am I
demarcation.
audible to your lordship?
By way of partition.
You will have your say after the appellant.
No, I just couldn't understand if I was audible. But I'll wait.
Huh?
I couldn't understand if I was audible, which is why I was just asking.
Voice,
I'll wait.
your audio feed is coming very faint, but we can somehow,
I understood that. Not
maybe if you don't
I
use the
just-
AirPods, it will be better. We don't know.
possible. Give me half a second. Well, I'll immediately rectify.
We don't know. Yes.
Malad, may I hand over this home for Malad? You have?
We have. Section 54. Appeals. Section 54 is appeals.
No, section,
54
I
is-
beg to be corrected, 56. I beg to be corrected, Malad. 56, Malad, I beg to be corrected.
This is not the provision for
Yes.
demarcation.
Yes, this is the only provision my lord will find under the act. Another provision is there regarding the Bengal Survey Act. That was 1886 Act, that is not applicable so for this. Now, my lord, what will be the provision?
This is an enabling provision,
Enabling
enabling the
provision.
revenue authorities to conduct a survey.
Yes.
This
that
is not, but there must be a provision where one can make an application for demarcation of one's land.
In respect of the private property, my lord, the only provision is by way of partition.
So, my lord, may I say, the order 26 rule 9 of the
Yes.
civil procedure code, or order 39 rule 7, my lord.
Yes.
In these two provisions is been invoked, then only sir demarcation can be made partial to the order of the my lord.
By the civil
Civil
code.
code. That's
Then only sir direction can be given. Your lordship know 26 rule 9 is admissible evidence or 39 is given now.
so there
There is no other provision.
there is no other provision.
No, because yeah.
Yes, yes. Assam Bengal my lord, this is
Deputy collector land reforms.
Yes.
Anybody can approach him.
Yes.
For demarcation of lands,
Yes.
and the demarcation is done irrespective of title, whoever it may be. If you want a portion to be demarcated, they will come and measure it and
what
Let
is
you
followed
know
from,
the bounds, that is. all.
yes, what is followed from your lordship, that is exact provision is the Bengal Survey Act. It is pre-independent, after that it was adopted. Now, in that act, my lord, anybody can apply before the collector for demarcation of the plot.
That's all, yes. That's all.
Demarcation of the plot.
Plot, yes.
Now, what is
So
the plot
one
area?
being comes and he measures it.
And if there is a plot, because if there is any dispute regarding the identification of the plot in question,
Correct, that is the only issue.
that is the only thing.
Yes.
He cannot say that he has purchased this portion of the land or that portion. It cannot be done.
So his writ has not been allowed.
No, yes.
But
My
then
lord,
why
what
are
is the
you-
directed for SDLR to consider the representation? The representation precisely on the basis.
SDLR, what is his authority?
Revenue officer. Madam. Is
The state government can enlighten your lordship regarding the authority of the SDLR to.
the revenue officer. A revenue officer RO, then the subdivisional within the subdivisional land reforms officer, he is also RO. Then DLLR RO, district deputy district land reforms officer, he is also an RO. Well, may I cut short? If I lordship allow me. Okay.
So he has just been directed to dispose of the representation.
Yes,
What
if
is
that
the
is
big deal?
in connection with subject to connection, that is in connection for the purpose of demarcation.
So he'll dispose it off.
Well,
There is no direction that he should demarcate.
here logically consider that what was the order passed.
Yes.
Page 43, last paragraph. That
Yes.
is the patent. The petitioner by his representative who has paid for demarcation of his purchased land, but such deal cannot be carried out till the
Cloud of title.
title.
So purchase, you are reading with great emphasis. The court has taken note that there is a cloud on the title.
No,
Yes.
sir, pending. That
Yes.
was taken.
Yes.
If that is, however, the respondent can consider this representative for the purpose of ascertaining to whether the purchased land of the petitioner involve any pending suits or not.
So what is the big deal? You can go and show him that these matters are subject to suit number so and so.
So therefore,
What is the apprehension? That is what we are
the
trying to.
apprehension manner can consider.
You
Once
say it is all it is all involved in some civil litigation.
yes,
Where the court has said that irrespective of the fact that it is in civil litigation, it
then
should be done.
if you are logically considered today, if it is demarcation is somehow has been said to be
It can be somehow done.
that is what manner precisely the then if the power
This
is
is
not
why
vested,
whether
logically considered
there is a real and tangible threat or an imaginary apprehension.
it was there manner the purchase the property which is there and
We are asking you, in your mind, where is the real and tangible threat arising from the order passed by the Honorable Single Judge? Or is it an imaginary apprehension in your mind that what if this happens? He has not said anything.
therefore manner whether the court can direct the SDLR logically considered.
It has not directed. It has said you consider the representation.
But then he had to exercise the power on the basis of something for the purpose of adjudication of the representation. That is why, man, precisely I have drawn your lordship attention. What
So
is the
therefore, instead of the SDLRO, we should do it.
civil court is the appropriate authority. That is
So you will go and tell him. Yes, in spite of that, if he
once the power has been granted to the Malarkari,
what power has been granted? That's what we are asking you.
if the representation has been made,
Yes.
representation for the purpose of demarcation of the land. This honorable director you should consider the
So
same.
he will allow it under which provision?
Precisely, if that is why.
Therefore, we are asking you, it is an imaginary apprehension in your mind or a real and tangible threat?
But that is why, my lord, I have on the basis that jurisdiction has been exercised by the SDLR.
What has he done?
No, the pendency of the earlier petition, the appeal was preferred, and pendency of this application not stays was taken. Now, my lord, the hearing will be done. Here, my lord, only the restriction has been made. The person to be.
You would have completed it within 8 weeks. If you had not filed this by now, it would have been over.
Well, over, my lord, here is restriction was made to the person who was party to that proceedings. It was restricted to the persons who were parties to the proceedings.
Where is the restriction?
Yes, my lord. Your lordship can consider. After giving respective representatives of the petitioner and the private respondent clients of Mr. Ghosh and Mr. Roy an opportunity of hearing. Because all the persons are not there at that point of time.
Obviously, those who are not before the court.
That is why, my lord, now, my lord, the persons who was left out are now before your lordship challenging that order.
Oh, you were not party to the writ petition?
No, the persons who are now before your lordship
Yes.
are not the party to that writ application.
He is Mr. Roy.
He is Roy.
He is
Yes.
Mr. Roy. His clients have been given. What
My
is he
client has
saying?
been given those who are party in that earlier report, but the persons who are in the present application has been filed, they are not the parties. Am I clear to your lordship?
No, sorry. Not.
There is 20 persons. Out of them, 10 filed an application for addition of party that was not being considered. Order was passed, which is impugned before your lordship. Those persons preferred an appeal. So these
After
persons,
this order.
yes, that is why precisely I want to draw your lordship's attention. Those
So how is that relevant to these proceedings? That's not relevant.
the same order is subject matter of challenge before the by some persons with the honorable division bench.
Oh, it has already been challenged.
Yes, yes.
Oh, you mean appeal in intra-court appeal? We thought we above the SDLR, maybe there is some authority that they have challenged. the order.
Look, may I just clarify one thing?
Yes.
With your lordship's leave, I'll just clarify one thing. Mr. Roy's clients, as referred to internal page 3, are the same people who are appellants before your lordship. I don't know what other appeal he's talking about. And because he's filed the appeal, he's gone ahead and stalled the hearing. As it has just fallen from this honorable court, he has gone and stalled the hearing. The SDLR has returned a finding that because the matter is sub judice, I'm not going to go ahead and do it. And just the circuitous manner in which they do it, they don't even file an application for stay. It's a condemnation of delay, a leave to.
This division bench order is of 10/9/24. How can it be prior to passing of the order by the writ court? Just see the order of the division bench. What is the date?
Delivered on 10th September 2020.
Prior to the how it can be appeal against that order?
Your lordship will forgive me, but probably your lordship's mic is off. I can't hear anything that your lordship is saying.
Wait, you can't hear us?
I can't hear him. I'm sorry about this.
But my mic, at least he should be able to hear me. But not.
I beg to be corrected. There's two in their interpretation it was challenged, but I no. I beg to. I beg to.
Just clarify that whatever he has to do in accordance with that.
That is precisely my lord. An opportunity of hearing.
Not able to hear us. What to do?
An opportunity of hearing to this process of.
His mic is turned off.
No, I can now. I had just put myself on mute.
You had.
I can hear you.
You had switched off on your side.
No, my audio, so that I could hear your lordships and not interfere.
The moment you switched it on, it started both ways. So there is nothing to be done. He'll proceed in accordance with law. That is all.
That's all.
Nothing else.
Only thing in accordance with it comes because my lord, if the suit will be.
Yes.
No, there is no issue of the suit. That is precisely the what
We
he's
are not
supposed
going
to
to enter into anything.
That's right.
We'll just leave
Let
it to
him
them to
decide.
exercise and we'll record his apprehension. That is all. Yes. Yes. The
My lord.
commissioner was the respondent before. Wherein there are no other parties to appear. All have appeared.
Only the petitioner. We have prepared this.
The intervener in the writ proceedings, claiming title over the plot of lands which demarcation of which was sought by the writ petitioner. The Honorable Single Judge has been pleased to pass the following order. The learned counsel for the appellant submits that since the appellants have vital interests in the lands and the lands are subject matter of civil litigation between the parties, he apprehends that orders may be passed affecting the rights of the parties pending adjudication in the civil cases. We find no reason for such apprehension, as the order of the Honorable Single Judge is clear, only to dispose of a representation, which obviously has to be in accordance with law. It will be open to the present appellants to join the proceedings and point out to the authority concerned. Respond number 2 herein also. Respond number 2. The claim of the present appellants. Respond number 3 herein, the claim of the present appellants, so that the same may be taken into consideration. The appeal stands disposed of. Give it back. Give that.
But I have one request to make.
Yes,
The
please.
order impugned had a timeline that was there. If your lordship could just consider directing, the order impugned had a timeline within which
Okay,
this
the
was to be
timeline has
completed.
to be extended. He is correct. Since the
Yes, and
Honorable Single Judge has allowed 8 weeks time, and the appeal was pending till date, stop, we direct that, we consider it appropriate that the timeline allowed by the Honorable Single Judge be extended by a further period of 8 weeks. From date.
grateful.
Yes, here it is very good.
Real effect is 43. Justice has suffered, Justice said, sitting, court suffered heat stroke. Not heat stroke, because such condition, just wait a minute.
Today,
In the morning, just sitting in the courtroom after calling 3 or 4 matters. All good. All good.
Pending application stands disposed of. Yes.
Item number 10. For the private respondent, there is writ petitioner in item number 10, lordship.
Lordship, my humble prayer. Lordship, my humble prayer, kindly please the matter on Monday.
Lordship, from the very first day, they are dragging this matter and praying for adjournment,
Actually,
lordship.
on the last occasion also, the learned conducting council appeared virtually, but due to the internet disconnectivity issue, he could not.
He is appearing, lordship.
Face his case. He will appear physically on Monday.
Wednesday. The last 3 dates, every case we have been taking matter. Since Monday, Tuesday, Wednesday, every case we are taking matter. Why don't you argue the matter?
Actually, I'm
not
not
getting the adjournment for all the matters. Would like to hear you. Start. We'll see what is.
Actually, I'm not engaged in this matter. Mr. Taraprasad Holder will appear physically. on
He is
Monday.
appearing virtually, lordship.
He's online.
He's trying to appear. You too.
And it's happening from the very first day, lordship.
What is that?
Actually, that's why I'm praying.
Now he is appearing virtually and every time he tries to speak, know what's come from his end,
What
lordship.
is your problem?
Lordship, the order they have challenged, lordship, they has already complied with the order, lordship. This is the notice that
Who has
they,
complied with you?
those who have filed this appeal, lordship.
Therefore, we are asking what is your problem with the pendency? How it is affecting you?
Lordship, already they have complied the order,
How
so
it is affecting you? Understand what we are saying?
yes, lordship.
So you are making such hue and cry that they are taking repeated adjournments. So
That's
we ask
why-
you, how is it?
Yes,
affecting-
I'm
Yes.
clarifying it, lordship.
Yeah.
They
They have
conduct,
complied.
they have conducted a hearing and by filing this appeal, lordship, they are not passing any order in terms
Who's
of,
not passing.
Shiliguri Primary School Council, Lordship.
What was the direction? Let us see.
Yes, Lordship. At page number 78, Lordship, the impugned order that has been challenged has been annexed here with Lordship. WPA 2547.
Challenge this offer.
Shiliguri Primary School Council.
You don't want to decide. Lordship. Yes, you don't want to decide. You don't want to decide their representation. You decide their representation.
And Lordship, this is
No
the notice
question of
that they
any-
have served upon me.
Hearing has been done.
Yes, Lordship.
Then.
But
let
by
them-
showing this appeal, they are not inclined to pass any order in terms of the order delivered by the Honorable Single Bench, Lordship. It's purely a frivolous appeal, my lord.
What is the next date fixed in the matter?
Hearing has been concluded, Lordship.
Complete.
Complete, Lordship.
Then only few days, currently
Sorry.
placed on a Monday, Lordship. He will appear physically, Lordship.
Not today. Tomorrow is the only opportunity you have.
Lordship, due to the
Next
internet
case.
disconnectivity.
Next case.
Obliged, Lordship.
Matter is adjourned for the day on request made by the learned counsel for the appellant. Full stop. It is made clear that no further adjournment shall be granted. Appearance. Item number 11.
We are for the state, ma'am. On the request of the applicant, matter has been fixed today on a.
Where is the requesting party? So what do we do? What is this arising out of writ? No. And then, what is the Mahakuma Parishad?
Yes, ma'am.
What is this? A Mahakuma?
It's a local body, ma'am.
Mahakuma is a local body. Hill area local.
No. Siliguri.
It's akin to panchayat. No. Town. Municipal.
No, corporation. Covers some larger area.
Council. Like a
There is
council.
a municipal corporation, it's separate, Manoj. The Mahakuma Parishad controls the some of the areas of Jalpaiguri and Siliguri, Manoj.
না, জলপাইগুড়ি district আমি কোনো করছি না। It is established under which provision? আচ্ছা, এই কি বলছো, তুমি এটা বলছো। Three categories of municipal units also. Anyway, so it's a local body.
Local body.
Have they returned the amount?
Malad,
Have they refunded the amount?
Malad, we are not representing the Parishad, Malad. We are for the state, Malad. Malad, they are not here for the refund, Malad.
Oh, the rate petitioner is the appellant. What does he want? This, the court has directed to return the amount.
Yes. They are telling that.
Probably he wants that the tender should be
What-
awarded. to-
But since the second tender.
Yes, that has lapsed in 24.
That is last year. He is only entitled to understand.
None appears on behalf of the petitioner in presence of Learned Counsel for the respondents. Matter is adjourned to Friday, give the date of.
The case number 9/20/25, memorandum of appeal. But my lord, this item number is defective. One of the reason, my lord, deficit of court fees, 20 rupees. And another is, my lord, technically mistaken, it has been type orders instead of DK.
So, what do you want?
My lord, give me a time to remove the defect.
That counsel for the appellant seeks time for taking steps to cure the defects. Stop. We allow 1 week for the same, for stop. Matter is made returnable in the next available set.
Lordship, I am for the petition.
Who is it?
Lordship, I am for the petitioner.
You were the petitioner.
Yes, petitioner wife appellant. And actually, affidavit of in opposition and reply was exchanged earlier before. But Honorable Justice Tandon asked us to submit asset and affidavits for hearing of the petition under section 24. That we have.
He
complied,
asked
but-
you, or the apex court requires filing of such affidavit?
That is right.
Yes.
That we have filed. We complied promptly, but they are taking time it can be hard on one day. Actually, his senior also called me for taking.
He has not even requested for time. He's just standing here.
No, my lord, I was about to ask for the same, my lord. The problem is the husband is an army man. So it will take.
That's not a problem. That's good. Yes.
So he will come here to sign and then.
Oh, affidavit is not ready.
No.
Affidavit is ready, but signature is pending, my lord.
So the affidavit is not ready for being filed.
Yes, my lord.
His senior informed me that on Friday he will swear the affidavit and it can be hard on Monday. That is why I am saying. He called me.
You're the appellant wife. The counsel representing the respondent submits that the affidavit of assets is to be filed in terms of the earlier order dated 13/3/25, however, the respondent being in the military service is not available for affirming the affidavit till date, full stop. He submits that the affidavit is likely to be affirmed on, give the date of Friday, stop. Let the same be filed after due service upon the learned counsel for the appellant.
Lordship.
List in the next circuit. Go through it. You'll have to examine what they are saying necessarily.
Lordship, next circuit.
Yes, it will have to be examined. Can't be done in.
Can it be taken up next week, Lordship?
Cannot be, sorry. When he comes, then he will see your affidavit.
On earlier session, we faced this same thing. It's at this circuit fixed. Thereafter, we are also going to next circuit.
Yes, next.
14 same advocate praying for on Monday, my lord, because
Why?
out of station conducting advocate for the time.
As prayed. As prayed. List on Monday. Give date of Monday. This person is down. This person is missing. Oh, what is it?
Can one is the.
Can one.
That's it. Can one is the application for injunction.
Position is filed.
No, that's it.
He has appeared.
They have
Yes,
appeared.
But since on 2 occasions, Millard, despite notice, the respondents could not appear, Millard, and
Ad
ex parte
interim.
ad interim order was
Injunction was
granted in their
granted.
favor. So that is there, Millard. So Millard, if Millard kindly considers the preliminary decree, Millard, the dismissal in fact, Millard, the observations are very clear. They could not prove themselves to be the
No.
owners of the property.
This is a.
No, first, before
No.
that, there is an application. You do
Yes.
not want to file a opposition.
We want, because we are opposing the, even the ad interim. prayer that
Therefore,
has
you
been
may
granted.
place on record your opposition. We'll
Definitely,
consider the
we-
matter
we will.
within a week.
Millard, 2 weeks, Millard.
So in that event, Lordship, the ad interim protection that is granted maybe.
Obviously, if it has continued till today, it will continue. The learned counsel for the respondent takes 2 weeks time for filing opposition to the CAN application. Stop. Let the earlier interim order of status quo passed on April 2 continue till the next consideration of the matter or till further orders are passed in the present proceedings. Stop matter is to be listed in the next available circuit.
Yes, sir.
In the meantime, it is expected that the opposition will be filed up after due service upon the minute of.
Grateful.
This is the matter.
Yes.
Lordship, I am for the appellant wife.
Scientific investigation. Oh, something for scientific investigation. What is there?
Lordship,
Memorandum has been provided to you?
Yes, yes.
Yes.
may I please, Lordship?
Yes.
Lordship, matrimonial shoot that has been disposed of during pendency of an application of section, under section 24 of the Hindu Marriage Act for maintenance pending amendment. That has not been considered before passing decree against us, that we have challenged. Thereafter, when we filed this appeal, can one filed, we have filed for section 24. As because lady is in hardship with two small daughters. She is getting only 10,000 monthly after having order of 12,000 per month.
So divorce has been allowed?
Yes.
Yes, divorce has been allowed. That we have challenged in appeal. That has been admitted, but formal call for order of TCS has to be made. I think that has not been done in the earlier. TCS has not been called for. TCS, not TCS.
Formal admission is required.
No, actually, call for in the record is
only that.
That is that I am saying. Formal order related to that.
My lord, may I submit subject to my lord's approval. Now there is an expertise. The wife filed a written statement, after that did not face the court. Adduce any evidence. After and in the written statement, the specific allegation of illicit relationship of the husband. On basis of which, my lord, the court is of the opinion.
Should be considered without the trial court records.
Evidence, so the evidence is concerned subject to question, my lord, those are with us. If my lord different ones, we can file that. Because
That is one way of doing it. The other way is
Yes.
having the records.
Then the paper book is
Then
some
we
other
can-
things.
Then
will
we
be
can
required.
consider the matter in the, it can be disposed.
I don't know, my lord knows. Hearing of this first appeal, my lord, before this, it will not endure to benefit of the either of the parties, subject to condition.
No, what is your proposal?
My proposal is, if your lordship can fix a date for hearing, we can prepare the information book and some, because all the evidence to be considered. Court has pointed to the evidence, statement filed by the wife. While some statement was made, those are unfounded because they did not appear not willing to controvert all those, apart from anything.
So you had produced witnesses?
Yes.
Evidence?
Yes, those are.
So should we not look into that? whether
Yes,
it
yes,
was-
that's why the documents are with us.
So you will file it?
Yes, that we can file it, so it can be expedited. That is the prayer I can make before your lordship.
My lord, according to my submission, according to my pleadings, that is, it is a fit case for absolute fiscal remand. And because why
whatever
failed
it
to
is, but,
adduce evidence, proper evidence, only because of lack of proper advice. And we are praying hearing of the section 24 application,
Let
can
the
one.
records come.
As your lordship.
Lordship, can one can be heard
Can one, what is can?
for maintenance pending like.
Let us see.
Then my lord,
Lordship,
parties
we have
it
already
they have,
filed.
in terms of this Supreme Court judgment,
How
near
many children you have?
2. They are residing my house. I am somewhere.
No, not that.
Is there any rigid statement? Why not from the document?
Not that, not that physically. That
Physical.
they are residing in Jalpaiguri, they are reading in Jalpaiguri. He is staying in Calcutta.
Where is your can one?
Jalpaiguri house belongs to me.
That may be there.
As-
There I am residing.
Yes, that is
There I am
why.
residing, but you are residing at Calcutta. Sorry. Lordship.
So my house will go.
Is there any finding of the trial court regarding the two children? Where they are?
Yes.
Where is that? Which paragraph?
Your lordship fine.
Because he has made a specific amendment in paragraph 11 of his application.
So what the
which remains uncontroverted.
Paragraph 11 of the judge. আমাদের একটি
ক্যান্সার ইস করেনি
জাজমেন্টে চাইছে
subject to question one probably the can the application has not been I could not find it out because only the memo of appeal passed to lordship direction I do not know my lord I
Please see paragraph. Give him a copy of the can application.
একটা কপি দিন আমি এখানে করে দিচ্ছি আমি একটা কপি হবে আপনার কাছে
এই মুহূর্তে তো রেডি নেই I can hand over today. I can hand over today.
ঠিক আছে
Take a copy. Can you file an affidavit by next
yes
week?
now the affidavit access record to be disclosed before your lordship both by both the parties now my lord it
That we have already filed, that is in LCR. If court directs, we shall file
in
again.
every stage
You have to file here.
yeah
Yes,
man,
we
that
shall
is
file again.
What is the liability? What is the asset
yes
today that has
it be of the Rajesh was yeah both has to file their affidavit
Lordship, let it be directed, both of us.
first have a copy of the can of
That I am giving today. That I am giving today, just after this
and
session.
in the meantime my lord necessary direction be passed so LCR can be called for and the
Lordship,
yes yes thank you grateful to
copy of the application is being served on Mr. Roy, appearing for the
এটাই তো
that counsel for the respondent. Stop.
we don't think he can allow.
Let the trial court records be requisitioned. Full stop. Special messenger cost for the same be deposited by, you deposit the special messenger
Yes,
cost
okay.
by the respondent within a week from date, full stop. Immediately upon receipt of the trial court records, the same should be verified and intimation sent to the and counsel for the respondent for preparation of informal paper books, requisite number of informal paper books typed cyclostyled or copied outside the court for consideration, full stop. Since the application is pending, it is also considered appropriate that the parties should file their affidavit of assets and liabilities to facilitate consideration thereof. Stop. Let such affidavit be filed within 2 weeks. Okay. That is made returnable now. It
and
can
my learned friend may supply a copy of their also the
obviously
if
filed
the-
within 2 weeks after service of after exchanging copies of the same.
the
Returnable
applicant be
next.
returned-
Next,
next probably my lord after that my lord
next to next, sir.
next to next subject to question my lord it
Yes.
comes
Next to next circuit. The circuit after the next. In the
Get
circuit
put-
bench after the next.
get full to lord
No, these copies, affidavits and assets and liabilities to be filed after exchanging copies of the same.
Lordship, question of formal papers will file in front of governors.
yes certainly we have to we have to
He will do
Otherwise the
it
department
here.
will not accept
He will do it. He is going to
department
do
will not accept unless they show that the service has been effective
Grateful, Lordship.
yes
This thing has just referred with after a delay of 1064 days.
1064 days.
Yes, ma'am. I have the can one application in section 5 application.
Have you served copy of the can?
I have served the copy of both the can application and the memorandum of the respondent.
You are saying you have served. It has been served.
In case of the respondent for 4 and 3.
Why do you say it has been served, sir? You want us to go through every document and then you should tell us who has been served, who has not served. You said application has been served. Factually incorrect statements, really, it is not appreciated at all. One has been returned, one address not located, 2 served. And you are saying it has been served. Very unfortunate that you should make such a submission. Your affidavit is not supporting what you are saying.
It is going that the item has not.
So therefore, you should say it is served.
served on the other respondent.
You should tell the court. You want us to go through every document and then verify whether we should be able to just take it from you when you say something. You effect the notice on them, or then only it can be done. Or you get up to date. It is because in respect of this
Yeah.
Seema Das, it was on hold. So we don't know after that whether it has been served or not. Insofar as Shipra Das is concerned, it has been returned. So for that, you will have to take fresh steps. Item returned, address you cannot be located. Or you take fresh steps for service on both, whatever you want. The service report, the affidavit of service has been filed showing service upon respondents 1, 2, and 5.
Hello, sir. Item number 18. Lordship, I'm praying for next circuit, Lordship.
Next, as prayed. Next.
20. Yes. And of the applicant. Now in your last order, after this one, yes, in fact, failed to comply with the order.
Fail to comply. Why?
Was directed to produce
So they find that rupees 50 lakhs to show his bona fides. And it was rather said that in the event respondent does not do so, the interim order that he has obtained is to find going, filed by him before the trial court may liable to the. In fact, this relates to a suit for specific purpose and is filed to suit after the expiry of the agreement of sale and after receipt of their receiving back the advance amount. It is the money, in fact.
So you have failed.
No, Lordships, I have complied with the orders of the honorable court. You know, I'm filing an affidavit in compliance with the order.
He says you have failed. You have
Yes,
not.
might be able.
There was a direction to produce a demand draft, not to hand it over to the appellant, Your Lordships. I have annexed a photocopy of the said demand draft. I have the original with me.
You are giving one copy. Filing one copy in division bench.
I beg your pardon, Lordship.
We cannot pardon you. You have to give 2 copies.
I have the originals with me.
Give 2 copies. Get another copy done. That's not the way to appear before a division. Come back with it.
Though,
Not
Your Lordship,
today.
there was no such direction regarding affidavits, Your Lordship. But I, out of my spite,
If you want to file, you file. If you don't want to file, don't file.
If the demand draft is recorded in the order sheet, then the affidavit
Since he is disputing, it is better you keep the affidavit on record.
That's the reason. That's the reason.
Don't take the responsibility.
I have a demand draft of 50 lakhs. With me.
Give it tomorrow. Come tomorrow, not today.
Lordship, may it be fixed day after tomorrow?
Day after tomorrow. Tomorrow with not today. Tomorrow with not today.
Without the one thing, I must be allowed to make some.
Let him submit the draft, then you will make submission. Right now it is for his compliance. Let him complete the compliance, then we'll hear you.
Tomorrow.
Can't be, he has some difficulty. Why? What
No,
is the
actually,
in one day, what will happen?
The respondent stays at Calcutta. Yes, he has
Therefore,
traveled.
when he is saying there must be, he is here with the draft. So let us see. Yes. 21 is the same.
I got 21. 21 I'm paying for not to them. But chatting was supposed to be.
But I am.
Who?
So only the chatting.
I am praying for Monday, if subject to Lordship's
He
convenience.
has to appear virtually, he can appear any day.
Monday, kindly.
List on Monday, as per prayer of the learned council for the respondent. Yes.
I never got into.
But that's who was also a German.
My lords, item number 22, kindly next week, Lordship.
Yes.
My lords, kindly takes it up next week, Lordship.
Thank you very much. But I have just received the brief. In the morning.
What is it arising out of?
Because in the morning I have received the brief, Milord. I know nothing about it, Milord. I am opening the brief right.
In the last 5 years, there are 3 adjournments. Therefore, we are wondering what is the issue. And today again, he wants an adjournment.
But it arises out of a Milord.
Matters are just to be kept pending for what we don't know. Huh?
The dismissal of a matrimonial suit.
What happened? His application for divorce has been rejected.
But I have received.
Dismissed.
Milord.
Yes, it is dismissed. Dismissed in 2019.
In 2020, Milord, directions of paper book was passed.
Paper book has not been prepared.
It has been prepared. I have been served with a copy of the paper book. 11th March 2020.
They are not living together.
Lordship, they're not living.
So from 2012.
But I have to take instructions.
Yes,
So
we
what
think
the
you should take
instruction?
instructions. 14 years. Almost 14 years. Yes. In the woods. You have instructions to oppose.
Lord, I'll take instructions, Lord, if something else has happened in between them, some kind of settlement. or
Yes,
that
this is now about.
Mutually, they have
14th.
separated, I will take instructions and come back.
The learned counsel for the respondent. Mr. So-and-so submits that.
Item number 23 and 24.
We rise.
It's a maybe.
It is. Nobody appears for the parties. Yeah.
But the marriage was dissolved by a decree of the court. Degree, I have for the husband. The husband preferred an appeal. The wife has also preferred an appeal. The husband was satisfied with the part of the marriage has been dissolved, but agreed with the further observation of the court that a particular portion of the joint property belonging to the husband of the family were allowed to be occupied by the wife. That was my demand. Now, Miller would find from the order sheet that on several occasions in the preceding circuits, it was considered, and the parties almost reached a settlement. Because only the wife was also agreeable for the separation, only an amount of money which was supposed to be final. My respectful submission that despite our best efforts, they almost had reached a settlement. If your lordships consider appointing a special officer who can sit with them, because mediation earlier has failed. Subsequently, this efforts of negotiating and these things have advanced. Appoints any member.
Where is the stalemate?
The same. No. The stalemate is with regard to the amount of